Good morning. Good morning. Can everybody hear me clearly and well today? Because I've been having those issues since my computer updated. So I want to make sure everyone can hear me properly and that I'm not magically muted like I was last time. So I'm just going to take a peek at the audio. Okay, it looks like the audio is working. So thank God. Good morning, Scorpio Moon Gal. Welcome, welcome. You can hear me loud and clear. Perfect. Oh, and we need to fix the bubble. Let's fix the bubble for a second. The ticker's not on. God, I'm a mess today. I'm sorry, you guys. Welcome to Twisted Tragedies, where we follow all the twists and turns wherever they lead. I am your host, Elise, and I am a disaster today. And I apologize. I still have a sore throat, so you'll hear me sort of clear it a little bit. Probably drink a lot of my water, my Propel, and and I'm a disaster of messes this morning, running around like a donkey. Update on my kid. They wanted to do another. They want to do the other surgery like now for her other hand, and my daughter was like, I would have no hands that I could like eat with. So if y'all could just wait a couple days. So they were like, yeah, let's go back to the original plan of waiting until about a week before they do surgery on the other hand. So we're still doing well and waiting for the free and clear on the second surgery, and then we'll move on to the third, fourth, fifth, sixth, and seventh, on and on and on we go. So yeah, she was like, no, I'm not gonna have no hands to do anything, right? Like, she's like, if I had, like, that wouldn't make sense. So they were like, yeah, you know what, kid, you're probably right. Like, so they decided they would wait on the second hand. It's not emergency like this one was. This one was the vein that was being compressed in her hand and causing extreme amounts of pain. And like I said, her joints are already fused, so her hand on the other side is like this. She can't do this. She cannot do this with her fingers. Her fingers are stuck like this. So she was like, listen, I already don't have this hand you guys did surgery on, and like this hand's already like kind of fucked up. You guys want to do surgery on it, so like I'm gonna wait until this one's like healed, so at least I have one hand, right? Like so it'll be this upcoming week, probably end of week. I'm thinking that they'll do the second one. So, but she's doing well, and I appreciate all the well wishes, and she appreciates it too. She's a very smart kid, that's for sure. And she's my baby, but she's not a baby anymore. They'll always be your babies, even when they're not babies, right? Well, we got a lot to talk about today, and we have the hearing at 11 o'clock. Good morning, Jennifer. Good morning, Leah. Wow, there was a lot of things that happened, in the last couple of days, and I was hoping to do a show on Monday, but yeah, no, that wasn't happening. Like no, it just wasn't. So here I am today instead, still sick, but with you all. I try to, pick myself up and dust myself off. So it's just my throat now. Thankfully, it's not my head anymore. It's just like this, whatever this is, strep throat thing, and it's obnoxious. So bear with me on that one. And the light isn't great. I don't know what's going on here. The sun keeps coming out, keeps going away. I have to keep, like, if I do this, then if there's too much light, like I don't know. It's hectic over here. You know what? Hold on. Let's turn on the regular light because I forgot to do that already this morning. This is my brain, okay? This is my brain on not a lot of sleep and stress, y'all. Like, so excuse my not a lot of sleep, stress, sick brain from being sick with strep. And since I'm still sort of like rearranging this room, this is the playroom / my streaming room. That's why we don't have my Twisted Tragedies signs and my Justice Ave Street signs up yet, because I just haven't decided exactly where I'm going to be in this room. So this is probably not going to be the ultimate spot. It's probably going to be somewhere over that side of the room. But, yeah, let's talk about that, shall we, Anna? So the very ever so brilliant genius, the sewer turtle, decided that it would be such an amazingly smart idea to dox the special prosecutor like he's a freaking 5-year-old going, bro, let me, let me just tell you, okay? You cannot dog whistle, threaten, intimidate the special prosecutor in a murder trial, okay? Like, that's not like, are you plugged in? I mean, we know he's not plugged in, but like, at least maybe some, I think that's wishing too much. Maybe some, just a smidge of his followers are plugged in a little bit, just a smidge, maybe a little. You would think that they would have been like, hey, bro, like, not a very good idea, right? Like, he is insufferable. He's more than insufferable. You have to listen. If I could tell you guys everything that I know right this minute, like, not that you're not already disgusted and utterly disgusted, but like, I don't know how anybody could be more disgusted, but you can be. You can be with you can be. So so there is a little bit going on over there, right? Like, you're doxing the special prosecutor. I got some other pretty random information that I'm looking into to see if it's real or not. If it is, it's a very large problem for him. A very large problem for him. But I have not confirmed yet. I am still waiting. So yeah, that's a damn good question, Anna. And I will tell you this. We're in Massachusetts. That's part of the problem. Hey, Jersey girl. And Massachusetts is criminal friendly. Let's put it that way. Okay. They give lots and lots of chances to criminals. Some of the problem is that they're not violent crimes, that he's not going out and stabbing people, or, you know what I'm saying? That they're not violent crimes. So like, it's, it's giving him a slap on the wrist, which I don't agree with because of the level. And I think half of the other problem is judges aren't supposed to know ahead of time about a case, right? So they're just going into it like right away as they're given it. And a lot of these judges are being given, this much of like the entire thing. And they do not realize that they don't realize the gravity, right? They don't realize how long this has been going on. They don't realize how many things. They're only told a few things, right? Like, they're not told all of the things and all of the people that have been harassed with the dog whistles and the mop. Like, they're not told all that. The judges are only told like, well, he did this and he did this and he did this. So they're thinking like, oh, he only did these things. Like, okay, well, it's alleged. So they don't get the full picture. And that's like part of the problem with the criminal justice system is like, they don't give like the prosecutor a lot of time to sit there and explain that the prosecutor doesn't have, 3 years, like, unless he takes to sit there and explain, especially when it comes to like an arraignment or something. But I will tell you this. I will tell you that everybody was blaming poor Cosgrove for asking for the bail revocation at the arraignment. It was not Cosgrove's fault. And I will tell you why. It was the judge that erred. The judge decided, and this is where I say, I'm sorry, but I really think that Stoughton District Court here in Massachusetts has got some really snaky, sketchy shit going on inside of it. And we already know that 2 people that worked at that courthouse were walked out last year and fired for giving him information. How do I know this? Because one of the people that were fired is my friend's grandmother's daughter, so my friend's aunt. And the grandmother called me to ask me to figure out what was going on. So we know of at least 2. Make no mistake, there's more. Now, does that include judges? I believe in this case it does. I believe in this case it does, because I have watched these Stoughton judges basically do jumping jacks to get around doing anything to him. And that concerns me. It highly concerns me. So Oh my, I can't with these people. And I tell them that the dog, not only did they get the bite patterns that we have from before John died, but they took casts of the dog's mouth. And also, FYI, because Hank is so very thorough as he is, he casted the dog's paws so he could debunk scratches. So aren't they in for just a rude awakening, huh? I can't with them. But so here's the problem with what the judge did. The judge said to Cosgrove, well, you want to do bail revocation. It should have been done at the first hearing, right? The first court hearing. Well, Your Honor, your interpretation of reading the statute is incorrect. I have never seen a judge read the statute that way. Why? Because the statute isn't written with the past or what ifs in mind. So when they write the statute for when bail revocation should happen, they are assuming that it is the first court appearance on that charge. Not that you have 19 other charges and that you had a scheduled court date for those charges. Because if Cosgrove would have tried to revoke his bail in Superior Court on the day that he had a scheduled court date after he committed the crime but hadn't been arraigned yet, the judge would have said, I have no legal standing to revoke his bail. He hasn't even been arraigned on the charge yet. So I can't revoke someone's bail who hasn't even been put in the system as having alleged to have done this crime until he is arraigned. So even if Cosgrove had asked the Superior Court judge to revoke his bail, the Superior Court judge would have said, I have no legal standing to revoke his bail. He has not even been arraigned on this charge yet. So I see people, blaming poor Cosgrove, like, well, Cosgrove did it in the wrong place. No, he did not do it in the wrong place. He did it exactly. And remember, Cosgrove's no idiot. He was a judge, okay? The only thing I don't understand is, why didn't he push back? Like, I don't understand why he didn't push back. Why not object and push back and say, Your Honor, your interpretation of the law is quite puzzling considering the statute doesn't read for if you already had charges and if you might have a scheduled court date between the time you committed the crime and the time you get arraigned. That's not how it works, right? And so this judge in Stoughton, I don't even know the guy's name, but like this judge completely erred in reading the statute or his understanding of the law, but I don't think that was a mistake. I honestly think it was very much on purpose. Because I've never seen a judge try to read a statute, a very clear one, and interpret it in that way. You cannot say, well, it should have been his first court appearance. Yes, it's supposed to be his first court appearance on that charge. His first court appearance on that charge is an arraignment or a clerk's hearing, but a clerk's hearing is to see if you have probable cause to be arraigned, so you still wouldn't ask for a bail revocation in a clerk's hearing. So it would be your arraignment. The statute doesn't go, oh, but if you had other previous charges and had a court date scheduled in between the time you committed said crime and the time you were arraigned, then you should ask for it there. That's not how it happens. And it's not how it should happen. The statute is pretty clear. I really am highly suspicious of the way that judge said that and then tried to sort of blame Cosgrove. Like, Cosgrove asked for that bail revocation in the exact place that he should have, in the arraignment. So I don't know. Something sketchy is going on in that Stoughton courthouse. But I will tell you that a lot of the judges in Dedham are quite tired of seeing him. They have to be quite tired of having him come before them at this point, because if you're just going to keep doing, and then you dox the special prosecutor, because you're just the most genius person on planet Earth. Hi, Ange. I didn't send links out yet because I forgot, and my brain. That's why, because I'm still sick. Oh, hi, Freak. Welcome. Free to join us. Oh, isn't that nice? I don't know. I don't know how you guys stomach it. I can't do it. I just don't get it. Like, but I mean, I just want to make clear that, like, if you want to do your own research, please do. Go read the statute. Cosgrove asked for it at the time it was supposed to be asked for. So for the judge to say the first court appearance, that is his first court appearance on that charge. It's not your first court appearance on any charge. That's not that's not how it works. So yeah, I can't either. I mean, I can bear to watch with some people, but I guess like, even when I'm not streaming, which I usually stream all of these, but like, even when I'm not, like, I can only watch certain people because I can't bear to watch any of the free Karen Reed people. I can't, because like the lies make me want to explode. But even some non-free Karen Reed people, I have now a tainted picture of who they are, knowing their motives, and I just can't do it. So I try to cover these myself, and I have a good place where people can talk and be kind to one another and watch it, you know, and just not have to worry about being bullied in chat, or being called names, or because you might think something a little bit different than someone else. Like, and that's what they do over there. They just attack everyone, their own included. Like, if you don't believe that the conspiracy exists, but you think that Karen, like, is innocent, like, you're still getting attacked. Like, that's how they work over there. If you don't buy their conspiracy and you think she was just drunk and hit him and forgot, like, by accident, then you still get attacked. Like, it's insane. It's absolutely insane. I don't know how anybody does it. Like, well, that's another thing. I don't like the condescending way some people speak to their audiences. There are just some channels that I watch or have watched in the past that I don't watch anymore, that are very, like, you can know a lot, right? And I know quite a bit, but no one's ever going to know everything, right? So if we can figure it out together, let's do it, right? Like, everybody has a strength in something, right? My strength might be the law, but one of you guys might have a strength in something else that goes together with what I'm trying to figure out, and we work together and we figure it out. I feel like some of these people who cover it just, like, completely dismiss that other people can help them when it comes to figuring things out together, and are just like, nope, I'm the know all be all. Like, that's it. Sorry. No matter what you say, I'm the know all be all. Like, I think it's also rude to your audience, the people that support you. I don't know. Like, interesting interactions. Yeah, I mean, I'm no lawyer, thank God. But because at this point, like, I would be ashamed. Like, I've always wanted to be one, right? Like, been studying law since I was a witness. Most of you know, since I was like 12. I was a witness on the stand twice in my life, once at the age of 12. Everybody knows the story of how I became fascinated with the law and why I started studying it, and how my life came off that path with my daughter's disease. And I would have already been an attorney by now, but like, watching these law tubers lie to their audiences knowingly for donations, it, it irks the F out of me. I just want to be able to explain the law in layman's terms to people, for them to understand, like, what might happen next. What does this motion mean? How does this come in? Why wouldn't that information come into a trial? Like, all of these things. I want people to be able to understand it on their own. So one day they don't even need me. They can teach someone else, right? Like, so it just, like, that's the most important thing to me, is that people understand it and don't just jump on social media like some of these free can read people do, and act like they know what they're talking about, when, like, it's very clear to anybody in the legal community that what they're saying makes no sense at all. So I want people to know how a trial works, what legalese, speak is in layman's terms. Like, so I mean, that's and partly now, after being in this case since 2023, and covering it this entire time, and dealing with the amount of harassment I've dealt with since the winter of 2023, like, now it's for justice, because every victim of this effing circus, every single victim, all of them, not just some of them, not just the witnesses and John's family, but every single person that has been victimized by these clowns deserves justice when it comes to this case. It's that simple. It is that simple. Like, that's kind of the problem, right? 2 jobs is like, how do you believe anything they say? You have to actually go and check, and then 9 out of 10 times you figure, like, it's not only just a bold-faced lie, but, like, maybe 1 out of those 10 times are they telling a part truth. That's the shit part. A lot of people have Scorpio. It's really sad. Like, I don't think she should be allowed to go to the scene because she's a very sick individual. And I think she will relish in what she thinks she got away with up to this point, you know? Like, I hope we don't hear a lot of Alessi today, guys. I don't know if my brain can do it. I don't know if my brain can do a lot of Alessi. I really don't. She is a narcissistic sociopath. But again, we have the sewer turtle. That's exactly that as well. You stick a bunch of people like that together, and what do you have? You have this mob, this court conspiracy mob of people, you know? It's sad, but it's true. And so I think it's important, though, that we go back to Hank asking for the text messages between Yannetti and Karen because Karen has waived her privilege. Most attorneys I talk to say the exact same thing. She's waived her privilege. I said this to you guys right when he came out with it. It is waived. She has talked about it numerous times, knowing the consequences. Like, so I don't know. Like, I don't know if Bev will actually give it. I don't know if Judge Cannoni will give what I think Hank is on solid legal ground asking for them. Most attorneys I talk to say, yeah, she absolutely, waived her privilege. There's no ifs, ands, or buts about whether she waived her privilege or not. But whether Judge Cannoni is going to give it is a whole nother realm. Like, I'm not sure that that's going to happen, you know? Like, so I don't know. I don't know. Like, the Commonwealth does always hit a brick wall with this judge, and I just think it's because she's so afraid of appeals, unfortunately. I think she needs to be less afraid of appeals and more worried about what's fair and what's right and what's on solid legal ground than somebody appealing her decision, because I just feel like she really does rule and sit on that bench afraid of appeals. And it's like, no matter what you do, and this is her, like, my point to her is like, no matter what you do, guess what? They're going to appeal. Karen's team's going to appeal everything they don't like. It's that simple. Like, like, well, I mean, you have to remember, like, if you watch that latest documentary, like, she shows you exactly who she is. She thinks she's all that in a bag of chips. Like, she never thought that there would be a second trial. So she thought that this documentary would come out after she was either found not guilty or guilty. She did not think there would be a second trial. So she had no idea how badly this would damage the second trial because they never fathomed a second trial. They didn't. They thought that, like, if it was, deadlocked, that nobody would prosecute her again. And I told people on the day that it was a mistrial, that she was going to be prosecuted again. Make no mistake about it. And how many of the cultists told me, you have no idea what you're talking about. You're a clown. You're an idiot. No, they're not going to prosecute her again. The FBI won't allow that. Of course. Here we are, folks, in trial 2, like I told you. Like, and also like I told you that the federal investigation was over a friggin' year ago. Like, oh yeah, well, that's the thing, is she needs to stop allowing them to sit there and lie in her court and misrepresent. She said she wouldn't deal with misrepresentations and lies and stretches of the truth. And then immediately after that, that's exactly what they did. And she did not a damn thing about it. So that's part of the problem, Oh, you did? Well, welcome from South Africa. What did you think of it? What did you think? I love to hear what, like, newer people that have never been here before, like, in my chat, like, thought about. And is this the first time you heard of this case, or were you following it already and then you saw the documentary? Like, it's just fascinating to know the answers to some of these things, right? Like, no, she did not think there was going to be a trial 2. Like, I think she'll be found guilty. There's 3 charges, so I think she'll be found guilty on at least one of them, and she will do some jail time. What time? I'm not sure, but there's one thing that I know for a fact, and it's that Hank Brennan is very detail oriented. He does not leave any stone unturned, okay? When he went down to get the information, and cast the dog's mouth, he also did the paws because he knew they would be like, well, if it's not dog bites, then it's gotta be dog scratches, right? Like, so he was like, yep, nope, I'm doing this too. Like, he makes sure that he's covering all the bases. Any little inkling of something that they tried to argue last time, he has a debunk for it this time. I do think they should have moved the courthouse as well. I also think, like I've been saying since the first trial, before that one started, sequester the jury. Massachusetts does not like to sequester the jury. I get it. You're taking away people's liberties and freedoms, and you don't want to do that. But I don't see how you get a fair trial with an honest amount of jurors who aren't lying to get on it, that are free, hear, and read, without sequestering the damn jury and making sure that they're not sitting on their phones and they're not going online and they're not, like, I don't know how you do that, you know? Like, come on. There is a lot more coming, I can promise you that. Quite a bit. There is, you know, a lot of that. Well, there are, ex-boyfriends, but as thus far, none of them wanted to get involved because they didn't. I mean, you can't blame them, right? Like, they don't want their lives upended. They have families and careers, and they didn't want to get involved. Like, they don't want to be sitting on the stand being like, yeah, she you know, chased me down with a knife or acted crazy. Like, they don't want that, because then people are talking about them. Then people are harassing them. Like, they didn't want any part in this, and I cannot blame them, not for 1 second. Like, that smirk was, like, so ridiculous. It's like she has no self-awareness whatsoever. And she does it as like she knows people are watching. She does it on purpose. She's like, "Ah, I am so innocent that I'm just gonna glare at you. How dare you say that about me, this innocent woman that did nothing wrong and that there's a 50-person conspiracy of. How dare you, Brennan?" And she just stares him down and then does the squint, like, oh, how dare you, and turns back. Like, the judge is watching you the entire time, right? Right? The entire gallery is watching you. The cameras are watching you. If people didn't think that you were a walked out before that, did you think that they magically? That's the self-awareness in her brain, in the brain of a narcissist or someone who is very egotistical. They don't realize what they come off as. Same thing with the suicidal. They think they come off as this amazingly awesome, cool human being that everybody loves so much. They don't realize what they look like to normal people, normal everyday people. Because they have these, like, this group of supporters in their ear telling them how awesome they are all the time. That's how they think that they look all the time. It's like, I'm telling you, their brains need to be studied when they're not alive anymore. Like, to figure out, like, what went wrong in there. Like, I can't, just like Scorpio just said, I can't stomach some of this shit. Like, I can't. I literally can't. Like, I can promise you none of those people had anything to do with anything. Colin wasn't even there. He left before Karen and John pulled up. Higgins was the first person to leave. Like, no, absolutely not. Like, so the fact that they even tried to name three-party culprits, and it's like, cool. What about all the other people that you magically? I argued with somebody this morning who was like, one of the EMTs that was an acquaintance of one of the kids of one of the witnesses, who had seen her at, like, parties with, like, groups of people and stuff like that, like group outings and things like that, was harassed into oblivion after she testified. And the person was like, well, I heard she said she had PTSD, and, like, I don't understand if you lied on the stand. She didn't lie. See, that's that cult thinking where, like, everybody told you she lied, so magically she lied. What'd she lie about? She didn't lie about anything. I go on a trip to Saco every year, okay? 2 years ago, we went on the Saco trip. A friend of mine, at last minute, decided he wanted to invite his friend. So he's like, "Oh, my friend's gonna come." And I'm like, "Cool, no problem." Right? We didn't know her. None of us knew her, right? She came on this 3-day trip with us. We did not know her. We got to know her while we were there, but like that doesn't then make her someone we're close to or someone we know because we're in pictures with her from that trip. She's an acquaintance to me and to everybody else who was there other than the person who brought her, right? So of course they argued that like because she's in pictures with Caitlin, like that magically it makes her like close to Caitlin, a good friend. Like, why would she be on a trip overnight? Because there were how many other people there? And from one of the pictures, it looks like they were either on a lake or on a river like Saco or something like that, where you often will meet other people there, like that you become friendly with too and take pictures with. So it's like, what? Like, what the hell? Like, what are you even talking about? Like, she was an acquaintance. She wasn't a friend. She wasn't a close friend. She was an acquaintance. Someone else that they knew her better and invited her to things like that. It's happened to me a billion times in my life. I'm sure it's happened to many of you. Like, I do believe that the buffer zone will be much bigger this time, Anna, and that it will go further away from the courthouse so that the jurors can't hear the chanting and the screaming, because that was a problem in the last one. So, I don't know, Eva. We haven't gotten that yet. Hi, Richard. No, we have not gotten the joint venture ruling yet. I don't know if we'll address it today. Guess we'll find out from the judge. I have Court TV and Law and Crime up on my screen, just waiting for it to go live. As soon as it does, it'll give me a thing and it'll tell me. But it just still says upcoming on both of them. So I'm just waiting for one of those to actually be live before we go to it. It's a few more minutes at the very least, I had to get a little talking to about my attitude to courtroom. Yeah. Let's see. Yeah, you can't be making faces at the witnesses either. That's like, come on, man. It's you're a defendant. Have some damn self-awareness. I don't care what defendant you are, for any defendant, for any case where there's a jury and there's witnesses. It's not a good look. Like, yeah, I think she should have told him to calm it down a little. The attitude, like usually the judges will be like, easy, you know? Let me ask you something. Does butt dials magically make Karen innocent? Does it take the tail light off of John's clothing? I don't think it does. Does it stop the data from John's phone and Karen's car from telling us the exact time John O'Keefe took his seatbelt off, the temperature of his phone, what time she backed up, and what time he stopped moving forever? Does butt dials change any of that? Because if it doesn't, then what do the butt dials matter? Give me one reason that butt dials would make any sort of difference in this case whatsoever. Because there is not a shred of evidence that anybody else besides Karen Reed committed this crime. And as a matter of fact, the federal investigation looked at just that, and they cleared everyone else. So the butt dials mean absolutely nothing. It is a ultimate distraction from the cult to say, well, there's all these butt dials. Well, there's 13 people in the house. Like, you have no idea the amount of butt dials I have done on my phone. And like, I love when people are like, oh, how'd you done it with your butt? Like, a butt dial is just an inadvertent dial. Do you know how many times I've done that? This thing could be in my purse and I'm actually Facebook like message chat like people by total accident with my phone locked, by the way. I have no idea how I've done that so many times. One time I did it like 4 times in a day and 3 times that week. Like, it happens, bro. Like, it just happens. It's life. Like, butt dials don't prove her to be not guilty. And it also doesn't prove that anybody in the house was, guilty of anything. You know what I'm saying? Like, guilty of anything other than inadvertently butt dialing someone. Like, I don't. But once again, we also know Richard Green was not reading the software correctly. So we don't actually even know what the hell he was looking at. There could have been maybe 1 or 2 butt dials from someone, and maybe the other ones never existed. I don't know. But what I do know is butt dials or no butt dials, it doesn't really matter. The butt dials are not in evidence to or for anything at all. There's no other communications of any kind from any of these people. Their communications and their geolocations were pulled by the FBI, and you got 0 indictments. So I'm going to go with, until there's some sort of shred of evidence that anybody besides Karen Reed did this, which there isn't, that the butt dials don't really mean much. Yeah, you didn't know, freak? Duh. Like, I'll tell you something. Peggy and Paul are rock stars. They are rock stars. But I don't think that they should have to go through that. I don't think they should have to, deal with her being at the scene. I mean, she's the defendant, so they're going to argue she has the right. I just think it's shitty, Should get a timeout. Right? It's like obvious. Duh. I mean, let's see what Judge Canoni does, Richard. Let's see, let's see. Let's see if please enlighten us on what they're lying about. Please enlighten us on what they're lying about. Scorpio said, even Kohlberg is saying that he has autism, just not to look weird. And I know he doesn't, because my son has autism. Yeah, my nephew has autism. And I obviously know other people that have autism. So I don't know. I haven't seen much of Kohlberger other than like his few court appearances. So I couldn't really say whether he has autism or not, but I can say that you still know wrong from right. So Karen can't lie without grinning. I noticed that too. That's like one of her tells, like a Cheshire cat. Everybody's butt dialed. Everybody on planet Earth is butt dialed. Please enlighten us on what they're lying about. So that's the thing, right? Like, you're saying they're hiding something. What if they just don't want their lives and their private, like, communications between each other, like sex messages or whatever, given to the public? Like, but there's nobody can point me to what exactly they're lying about. All they just keep saying is they're lying. What are they lying about? What are you claiming that they are lying about exactly? Like, like what? What exactly are they lying about? The conspiracy is a red herring, and even the jury knew that. That's why they didn't buy it. I mean, I don't know how any normal people don't see that at this point. The jury did not buy the conspiracy because it didn't exist. It's not reasonable by any stretch of the imagination. Oh my God, I have done it so many times. So many times. It doesn't prove that they did anything wrong, and it doesn't prove Karen to be innocent. So it literally means nothing. Like, yeah, the FBI must be in on it too, Anytime it's an answer they don't like, it's, everyone, I was added to the list of like in on it forever ago. So I must be in on it too, Thank you. Thank you. Thank you, Kelly. Thank you. She said, where's the proof the people in the house are lying? The only person lying and changing stories is Karen Reed. Well, here's the funny part. Is they can just keep saying like, all the witnesses are lying. All the witnesses are lying. Except there is 0 evidence to prove that they're lying about anything, and all their stories match. So, and it matches all their testimony that they've given previously. What I love that happens is the cult will take like one word that they used that was different. Like, last time they might say, like, have said like, I was sad. And this time they might have said, I was distraught. And they go, see, that she didn't say distraught last time. She said sad. That's a lie. Stop it. Y'all live in banana land. Like, stop it, culty. Stop. Don't do it. Like, use your common sense for 5 seconds and don't just spew something out because the cult said it and you're parroting it. Think about it. Okay. Just because they used a different word to describe the same thing this time doesn't mean they're lying. Like, what? Like, That doesn't even make sense. Like, you don't butt dial? What do you arm dial? I butt text rather long and complicated writings. Mortality of humans. Either that or I just mash the virtual keyboard with my ass. Yeah, well, yeah, we've all done it. I've done those too, those long text messages accidentally. My bad. Like, yeah, she sure did. She also told Jen that the waterfall was the last place that she saw him. If nobody remembers that. Karen told Jen, oh, the last place I saw him was the waterfall. She's like, what are you talking about? I saw you outside my sister-in-law's house. So who's lying about what now? Try that again. You know what I'm saying? Like, it's a very real possibility. They could have just had shit that they didn't want anybody knowing their business, but please point me to where they lied. And not just their people's opinion that they lied. Give me proof they lied about anything. It can't just be pure speculation that they lied because the cult keeps saying they lied. What did they lie about? What? Please enlighten me on what they lied about, because I know a whole lot more than most people. And I have a whole lot more pieces of evidence to prove and debunk things than most people. So, like, please tell me they lied about selling the house, because that house was already going to be sold before John died. And there's communications to prove that. So, like, please, for the love of God. Sometimes I think that they just put these rose-colored glasses on and they go and they watch all the comments that, like, the bigger cult people say, and they just and you can tell because they'll literally repeat word for word and parrot word for word what one of them said. And so then it gets repeated over and over and over and over and over. Like, no, but where's the answer? What did they lie about, Nikki? We're still waiting for that answer. I'll happily answer this, but, like, what'd they lie about? If you're not going to give me an answer, then please don't keep saying they're lying. I mean, you're saying they're lying, but you can't even say what they're lying about. Don't you think that's kind of a problem? That you're just repeating something that you heard without looking into it yourself? Like, they didn't lie about anything. There was nothing they needed to lie about. What about the wounds? The impact wounds cover his forearm and well above. His body isn't fixed to the ground when he is supposedly hit. Did the tail light explode? What do you mean, did it explode? That doesn't even make sense. What do you mean? What do you mean, did it explode? First of all, it was 18 degrees out. Number one, 18 degrees out. Let's remember that. So it'd be easier for that taillight to break in that kind of cold. Number one. Number two, they don't cover his forearm. There are scratch marks, abrasions, if you will, on his arm in places, which, by the way, match the taillight pieces that were found, just FYI. And what do you mean his body isn't fixed to the ground? I mean, unless you nail him down, of course his body isn't fixed to the ground. I don't know. I'm not understanding what you mean. Like, people seem to forget that he wasn't just hit head on with the front of a vehicle. He also wasn't hit dead center in the middle when it backed up. He was hit by the side of the vehicle, like to the side of the vehicle in the back, not dead center. Like, well, that's the thing. If you're going to say they're lying, please tell me what they're lying about. You know, don't move the goalpost to something else. We'll move on to that after. But I mean, come on, man. If you're going to say they're lying, I would love to know what it is that they're lying about exactly. Still not on yet, guys. I'm checking now. Yeah, it was found in the fabric of his clothing. Like, well, she's never going to answer them because you can't answer them. That's the problem. You'd have to make something up to answer it. You'd have to. Like, she does not have a piece of rug with DNA on it. I can promise you that. I can promise you that. You can have reasonable doubt all you want, but some of you just throw stuff out there and hope that it sticks with no evidence. You can't just say they lied and that's my reasonable doubt with no evidence they lied, because no jury is going to do that. Reasonable doubt has to be reasonable. It can't just be a mantra that a cult repeated over and over and over and over until 17 more people repeat it, and then 17 more people repeat it, and then 17 more people repeat it. Do you see how that's a problem? Yeah, let's do that. Let's talk about the dog bites that leave zero DNA and how most of the cult still to this day, and I'm sorry, but this has got to be the stupidest thing I've ever heard in my life. And yes, I'm going to say stupid this time, because if you're going to claim to me that the pig DNA is from a pig ear that the dog ate, but there's no dog DNA where the pig ear would be, then you are effing brainless. You have no brain cells to rub together. There would not be pig DNA without dog DNA, in which there is zero of. There's not a dog hair. There's no dog DNA. It does not match Chloe's bite patterns, what's on John's arm. So explain that one to me with his injuries. Does not match Chloe's bite patterns. There is no dog DNA. There is no dog hair. There is no dog anything, and it doesn't match her paws or her mouth. So tell me again how it's a dog bite or scratch or attack in any way, shape, or form. Please, for the love of God, tell me if it doesn't match. How? Also, how do you bite a human without leaving any DNA or a hair or anything? No puncture wounds, no bottom jaw, does not match her bite patterns before John O'Keefe died or after, for that matter. So you can't say she lost a tooth, it changed, because they have them from before and they have them from after. So yeah, there's no piece of rug that magically has DNA on it. You can bet your ass that if there was a piece of rug that magically had DNA, it would have been tested by now. Also, the court doesn't just let you bring in a random piece of rug and say, there's DNA on this. We want this tested right now, because we don't know where you got that from. Like, you could have plucked one of their hairs out or waited till they threw their trash out, taken their DNA and put it on a rug. Like, nobody, that's why there's such a thing as it's got to go into custody and be tested by an actual lab. Like, there is no rug that has DNA on it. Okay. Because John never went in the house, number one. Number two, their floor was redone after it like had a flooding issue. Like, and get ready for it, guys. Get ready. I know this might knock your socks off. There's documents to prove when the floor was replaced. Imagine that, huh? And why? No, they didn't lie about 8 butt dials in 2 hours. You have a guy who's not reading the data correctly. He had to admit that he wasn't reading the data correctly. Celebrate then had to put a patch out because he was not certified in that software. He called Ian Whiffen. Ian Whiffen called him back, and Mr. Green didn't bother to call him back. Why did Mr. Green call Ian Whiffen? For help reading it. He needed help because he was not certified in the software. And as so eloquently Miss Hyde and Mr. Whiffen explained on the stand the last time, 2:27 a.m. never happened. That is what time the tab was open. A DB wall file does not give you a timestamp for a Google search. It is what time that tab was opened or closed on her phone. And I would love to know, like, this is my best comeback when it comes to this nonsense is if you are trying to cover up I'm sorry, what? Now you're just playing move the goalposts. Nobody said they were easy to break. I said it's easier to break in 18 degrees, and that is a fact, an absolute fact. So once again, and I'm not the jury, so it's not my job to do reasonable doubt. And also reasonable doubt has to be actually reasonable. People confuse reasonable doubt with just any doubt at all. It has to be reasonable. All right. Richard Green went to Ian Whiffen because he didn't know how to read the Celebrate software. Ian Whiffen called him back. Richard Green never called him back after that. Then he had to apologize on the stand for reading it incorrectly. Celebrate had to do a patch, right? Ian Whiffen and Jessica Hyde had to get up on the stand and explain how at 6:23 and 6:24, the house long to die in cold happened, and how Karen had already asked numerous other people on scene the exact same question. That's not rocket science. It's also not reasonable doubt when she asked numerous other people on the scene. That's not doubt at all. And yeah, the deleted calls. Never happened. There were no deleted calls. The phone puts them into the background. They're not deleted. They're deleted from that screen by your phone, not by the user, by your phone, because it can only hold so many. Like, they were very drunk. Like, but butt dials or no butt dials, like one way or another, butt dials mean absolutely nothing. Do I understand physics? Actually, I understand physics very well. Do you? Because if you're going to tell me that that taillight isn't easier to break in 18 degrees, you would be wrong and you would be lying. So, which one is it? Like, the head freak, do your thing. Freak said, of course his body isn't fixed to the ground. But it takes time for momentum to be transferred from one body to another. He started from a point of relative rest. Yep. Hey, Parson. I mean, even Arca said it was easier to break in the cold weather. It's not, that's not like a real hard thing to figure out. Like, shouting into the wind, you don't want to discuss, you want to regurgitate the straw man. Well, that's what all we're doing is screaming into the void about what the cult taught people. None of it actually true or any evidence to it. The defense are going to be in very big trouble. They have been found to have lied to the court on purpose over and over again. I don't know why this hasn't started yet. This is kind of getting on my nerves. Over and over again, purposely. And that's not going to be, oh, wait. Hold on. There we go. Hold on.
Hey, sweetie.
Honey, everything okay?
What happened, hon?
My Spencer having you.
Ooh, we got to go back a little. We must have missed 2 minutes, 5 minutes. I don't know. It didn't pop up. All right. Oh, no, 3 minutes maybe. We're going to be a smidgen behind, but that's okay. I like being a little bit behind. Come on. Sometimes it starts like right in the middle of the hearing. It kind of pisses me off. No, yeah, we're not that far behind.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms. Reed.
Ms. Little.
Morning, Your Honor. Robert Alessi on behalf of Ms. Reed.
Mr. Alessi.
Good morning, Judge. David United County.
Good morning, Mr. Reddy. Good morning, Ms. Reed.
All right, so before we begin, Mr. Jackson, when we left the other day, when we were talking about Michael Easter, I gave you the opportunity to get some authority on expert testimony and voter defense. Were you able to do that?
We were.
Do you have something to file?
Yes, it was filed yesterday. I do have a courtesy copy for this one.
Okay.
And I can, if the court wishes, we
No,
can take that on.
that's,
That's gonna suffice.
I think so. I'll take a look at it.
It's got everything in it that I would say, or anyway, if the court has any questions, I'm happy to answer any questions.
All right. Thank you. All right, so thank you. So similarly, regarding the third-party culprit argument the other day, Ms. Yanegi, I see you did file something late yesterday, so I got that. I'm just wondering if either the Commonwealth or the defendant want to be heard on that.
The Commonwealth does.
Okay, so I'll hear you, Mr. Murphy.
Your Honor asked for a proffer from the defense regarding third-party culprits. Alternatively, evidence that would be separate regarding third-party culprit aspect of Bowden. We received some information from the defense that does not distinguish whether their intention is that it applies to third-party culprit or whether it applies to a third-party culprit aspect of Bowden. Those concepts are logically and legally distinct. Regardless, when you look at the proffer by the defense, it is insufficient and inadequate for both third-party culprit and for any third-party culprit aspect of Bowden. Two different analyses, but the evidence is equally feeble for both. Relative to third-party culprit evidence, there are a number of cases that I know Your Honor is aware of that guide the standard of third-party culprit evidence. Not to iterate the law because it is clear, but there must be relevance, there must be a substantial nexus between the claims of the defense and the third-party culprit theory. They provided us 3 people that they identify as third-party culprits. It's helpful just for a quick synopsis of the history. In this case, prior to the first trial, the defense never identified a third-party culprit. At some point, the defendant herself said that they knew who the third-party culprit was, and recently, the position of the defense has shifted that they don't know and don't need to know. Now, the law accommodates specifically identifying somebody. It also accommodates general, but it has to have specificity in the complaint. There has to be a motive, an opportunity, and an intention. There has to be evidence that draws the correlation. It can't be bad character, speculative, or just putting out information that's negative towards a witness so that that can backdoor prior bad acts against a witness and be used for a different purpose. They identified one person, Colin Albert. And in their proffer, what they offer, number one, and it's important to take them separately because it shows how feeble it actually is. The first thing they say about Colin Albert is he had a feud with John O'Keefe in the weeks and months leading up to January 29, 2022. Now, other than maybe on social media or in interviews with the defendant in national broadcast, there's no evidence of that.
Nope.
There is no evidence that's going to be admitted at this trial that shows there was a feud between Colin Albert and John O'Keefe. There is no evidence that there was any hostility between Colin Albert and John O'Keefe. There's no evidence of a motive to kill John O'Keefe by Colin Albert. There is no evidence of any motive, of any intention, or of any opportunity whatsoever. In fact, the evidence is that Colin Albert was not even at 34 Fairview.
That's right.
John O'Keefe arrived there on January 29, 2022. And so simply saying it is not evidence. And an attorney should not be allowed to confront a witness about an allegation that has no factual basis.
Nope.
And to then have to defend the accusation.
Nope.
The prejudice then seeps to the jury, and the Commonwealth is in the position of having to disprove a claim that had no basis to begin with. The second claim that they make regarding Colin Albert is that he had thrown beer cans in Mr. O'Keefe's bushes and told Mr. O'Keefe to F off in his face.
Karen debunked that.
There is no
herself.
basis for those claims. There is no witness for those claims. There's no information regarding those claims. I understand there may have been a party where there was beer cans, but there was no Colin Albert. So to attribute a situation or incident to him, the defense would need some good faith proof, actual proof, fact, that this actually happened. And there's no evidence whatsoever that Colin Albert threw beer cans in Mr. O'Keefe's bushes and told him to F off. And the reason there's no proof is because it didn't happen. So again, the defense asks for an invitation to simply cross-examine a witness, allege a prior bad act, and then the witness has to defend their honor and the government has to disprove it. That is not the cloth that third-party culprit is made from. Regarding the suggestion that there was some type of feud or tough relationship, I saw on a video that there were 2 radio personalities, and I have the clip, who spoke and met with Karen Reed. And during the conversations, at least they relate that there was some claims about a drug issue. And according, not to the defendant, but according to the interviewers who supposedly interviewed her, they said that the story is completely false. They attribute this to Karen Reed. People are trying to make it more dramatic, like Colin would have a reason to hate John O'Keefe. That never happened, referring to some drug claim. He did not report him for anything. And so what we know is there is no history of animosity between Colin Albert and John O'Keefe. We know that there was no animosity between his family and John O'Keefe. The only event known is that at some point, Colin Albert's younger brother ran across John's lawn. Mr. O'Keefe supposedly yelled at him and then bought him candy as an apology. That's it. So we have an alleged third-party culprit, a very strong claim, with no evidence, no motive, no opportunity, not even present at the time that this alleged collision occurred. And so in that absence of evidence, it's not even feasible. Colin Albert should not be brought to the stand, attacked with acts that didn't occur, that otherwise would have no admissibility. Really, it seemed to be a backdoor way to tarnish his reputation and then bind him with other people the defense would like to attack, to make a general suggestion that somehow this group of people are bad people. I know at the last trial, there was pictures of Colin Albert's knuckles that were scraped, and inevitably it turns out that picture, and I think the exhibits were introduced at trial, was taken much later. Pictures taken before that point show that Colin Albert's knuckles on the 9th and 11th of February weren't scraped at all. So because he had scraped knuckles, subsequently, because he may have done a video that some use would maybe do and threaten somebody else, not John O'Keefe, has nothing to do with this case whatsoever. It's an attempt to introduce alleged aggression or prior bad acts, but there's no bind whatsoever. The second person that the defense would like to identify as a third-party culprit is Brian Albert. And this is some of the gross generalizations that you see with Colin Albert. No specificity, but trying to assault his general character by generally suggesting things that may or may not be accurate in just telling part of the story. They claim he didn't have a good reputation among fellow police officers. No evidence. They claim it, and even if it was so, has nothing to do with this case. Known as a bully, so rumor clearly is not admissible in a criminal case. Had a history of sucker punching officers. We don't see any specificity. We don't see any evidence. We don't see any information. We just see a general attempt at a character assassination to portray him as somebody who is either capable or a bully. Nothing relative to John O'Keefe. Nothing. They suggest, and I'm not sure what the basis for this is, that he was drinking heavily that day when he went to a funeral with Mr. Higgins and another person. It is true that he was at the hillside around 9 o'clock and was drinking around 9 o'clock. So all of this information is just general inflammatory accusations about character. They say he was a trained boxer because when he worked out, he boxed and he was engaged in charity events, some dating back to 2003. By that standard, anybody in the neighborhood who has any self-defense training, mixed martial arts, or boxer would be on the target list. The fact that he is a police officer and that he is physically fit and that he trained to protect himself doesn't make him a third-party culprit. It is this general suggestion of strength and distorted into a hopefully perceived sense of violence that it has no root at all, no root. They went as far to say he was investigated by BPD for violent conduct, but they don't give any details. If they looked, they could go online, they could investigate potentially. There is no sustained findings that are known to the Commonwealth against Brian Albert in internal affairs, none whatsoever, ever. And so to make the suggestion he was investigated by BPD for violent conduct, they provide no fact. I'll say, even though it is off base entirely, it has nothing to do with John O'Keefe. They're trying to suggest that he has a propensity for violence. And they don't do it very well because they provide no details. These are all just general accusations by the defense. In fact, I would say it's not important or admissible. You can't bolster the good character of a witness, but to simply make suggestions of bad character is not any root or tethering to this case specifically. Instead of bad character, Brian Albert was a two-time recipient of the George Hanner Award, has many, many medals of honor from the Boston Police Department, but that is not the issue. They suggest that he was involved. So they know that they have to tie him not only to the scene, but somehow to Mr. O'Keefe. And other than being at the bar that night and Mr. O'Keefe and Miss Reed pulling in front of his property that night, there is no association between the two. They say he's present at the scene of death. By all evidence, Mr. O'Keefe died feet from the street near the flagpole in front of 34 Fairview. So that's a little bit broad. He wasn't present at the scene of the death. He wasn't there. That happened out front on the front yard near the flagpole, about 70 feet from this house. The body was found feet from his front door, arguably, okay, 70 feet, 75 feet. He admits to being home. He doesn't have to admit he was home. Now, here is another claim without any evidence whatsoever. The defense states emphatically, computer forensic data overwhelmingly establishes O'Keefe entered Albert's house. I haven't seen that evidence. Based on what? So if they're going to make an offer of proof to the court and they're going to make claims to substantiate this theory, they have to have proof of it. And in their motion, I see no proof whatsoever that overwhelmingly establishes John O'Keefe went into the Albert house. In fact, what we see is the opposite. In the past trial, numerous people were called. Every single person that was asked stated they did not see John O'Keefe enter that home. Every single person. Now, whether you believe it or not is irrelevant. What's relevant is there's nothing to the opposite. There's an absence of evidence to the opposite. In fact, the phone data and the Waze data and the GPS and all the data puts John O'Keefe at the front yard, not in the house. So if they're asking the court to make a finding of substantial link and substantial proof that John O'Keefe was in the house, they have to actually give you the facts and the science and the data to support that. And I don't expect that will happen. They add that there was going to be expert testimony that the scratch on John O'Keefe's arm was from an animal or a large dog, and because Brian Albert had a dog in the house, there was some type of inference. Dr. Russell has already testified at the Lanigan hearing that she's not saying that those bite marks were from Chloe. Although it has not been decided by the court, Dr. Crosby has done molds that show that the teeth comparison is totally an opposite. And so even the defense is not saying, as I see from the disclosures, that Chloe bit John O'Keefe. Their version, which we don't agree with, is that a large animal or a dog caused these wounds. They don't say where, they don't say when.
Not Chloe.
They don't say how.
Ha!
And so that is not a link so that Brian Albert becomes a third-party culprit.
Nope. Not his dog, right? It's just
Finally,
any animal.
in a way to try to create some type of traction against Brian Albert, they associate him with Brian Higgins because they spent the day together, because Brian Higgins, according to them, was rebuffed because of phone calls at night. All of these general claims with no fact predicate rely on innuendo, surmise, speculation, or just the creation of an inference that does not exist. There is no evidence Brian Albert had any motive whatsoever to harm John O'Keefe. None. There is not one witness, there's not one statement that Brian Albert had any animus whatsoever towards John O'Keefe. None. He did not have the motive. He did not have the opportunity. And there is no evidence that he was involved in any way in the alleged collision that happened in the front of his yard that night.
Nope.
Finally, the defense turns to Mr. Higgins.
Brian Higgins. Yeah.
Mr. Higgins was at the Albert address that night. John O'Keefe never went into the Albert address that night. They take very, very select pieces of information, and I would suggest don't tell the whole story. And from that, they want us to speculate a motive. For example, they say that Karen Reed had kissed Mr. Higgins at John's house. That seems to be corroborated in the text messages. According to the text messages, Mr. Higgins essentially says that Miss Reed came up to him and planted a kiss on him. And there's quite a bit of text message exchange that you heard during trial about that interaction. And then at some point, Miss Reed went to Mr. Higgins' house. And so there was some interest, it would appear, from the text messages between the two, mutual at best. There's a plethora of text messages where Miss Reed is pursuing Mr. Higgins, looking for his time, looking for his attention. In one, she says, of basically begging him to come over. Do you like me? Come over to my house. There are text messages talking about Mr. Higgins not having enough time for her. So there is a flirtatious relationship between the two of them. What we don't see is that somehow that creates a motive for Mr. Higgins to want to hurt or kill John O'Keefe. The fact that they are texting together and later that night he sends a text message because I think an inference the defense would raise is that he felt like he was ignored or wanted to know what was going on with their relationship, is not evidence of motive. In all of these text messages, you never see any animosity towards John O'Keefe. Mr. Higgins' text messages are virtually all kind towards John O'Keefe. It's uncomfortable. It's an awkward situation because both of them appear to be deceptive as it relates to John O'Keefe, but there is no vengeance, there is no anger. And so the suggestion that there is a motive because there was flirtatious text messages to then kill the man is beyond the pale. It's beyond any logical connection that would support third-party culprit. Brian Higgins sent a text message saying to John O'Keefe, asking if he was coming to the home that night, and they then attached the word he lured them to the house. I mean, we do look at this evidence not in a vacuum, but logically and realistically. Not knowing that Karen Reed was not going to come in when they arrived at the house, is it reasonable, is it rational, is it lucid to think that that Mr. Higgins was inviting them both over to the house, not knowing only one of them would get out of the car? Is the suggestion that Mr. Higgins was going to kill both of them? Or he was going to kill one of them, so the other one he would then set up for murder so that he wouldn't be able to see her anyways? The absurdity of the relationship between the claim and reality is so great that it will just run rampant through this trial. It would be unrelated, speculative, shotgun approach to claims that the witness will spend their time trying to explain and defend. It will distract the jury, and it will serve the purpose, which the case law says it shouldn't, of taking attention off the facts at issue for the case we're here from. And that attempt to divert anybody but the defendant is the attempt here. That's why we have three, we don't know who, but three potential third-party culprit evidences with absolutely fragile evidence. It's feeble. As their support, what they offer is they believe Mr. Higgins lied because he went to the Canton Police Department to do administrative work. And I think the evidence is clear that he had cars that he parked there as part of his job that he needed to clean off. So they are parsing words in an attempt to create a basis that doesn't exist. That there are calls between Mr. Albert and Mr. Higgins later that night. So what? They have no evidence that either of them spoke to each other. They have no evidence of conversations. They have no evidence of a conspiracy. They have no evidence of a cover-up. They have no evidence of a weapon. What we know is John O'Keefe never went in the home. And so to try to create this image based on obscure facts is not the substance that's required under third-party culprit. I know third-party culprit is a time-honored tradition and is a broad latitude, but it's not endless. It can't prejudice the Commonwealth. It can't distract the jury. It can't be based on fiction. It has to be based on an identifiable theory. The cases that have allowed third-party culprit that have been reported have actual people who could be a third-party culprit. who actually have relationships to the scene or the crime or the deceased. In this case, an attempt to call Mr. Higgins a liar or create fictions about what they think he could have been doing or guessing what they want him to do is not evidence. 9 people testified John never came into the house. 9 people. There is no overwhelming evidence or any evidence he went into the house. There is no evidence of motive on any of these 3 people they identified. They've had, before the last trial, the entire trial, and was aptly pointed out, no request for a third-party culprit instruction. And then they had since then to make an actual proffer that people actually have the motive, opportunity, and intent to do this, that there's actual evidence that there's this alternative theory, and they failed to do it. To have the defense go through a trial, distract the jury, attack the reputation and character of the witnesses, and then not even ask for an instruction at the end, it evidenced the fact that there is no basis for a third-party culprit. Now, separately, third-party culprit is part of Bowden. Even if the defense at the end does not warrant an instruction, I recognize that challenging the police investigation is virtually an entitlement of a defense. How they do it and the extent they can do it is a different story. Simply because they have an attack on the police investigation does not let them use third parties as part of that. And so the standard, Silva Santiago, is very clear, it's cited by almost every case, is that there has to be something the police didn't do at the time that they knew about and should have done. So at the time the police did their investigation as being
Told you guys.
they would have had to have known
Yep.
about a potential third-party culprit
And
or
looked
third-party
into
culprit
it.
evidence and didn't pursue it.
And they
that's where
didn't.
The defense argument utterly fails here.
Me, I do.
Because at the time the
Breadsticks.
police were doing this investigation,
I go to
what
D&E
they
anytime.
is that John O'Keefe was on the front lawn of 34 Fairview near the street. They knew that he was dying or is dead. And a number of witnesses knew that Miss Reed was saying, I hit him, I hit him, I hit him. A number of witnesses.
Yep.
Shortly thereafter, what the police knew is that Miss Reed's taillight was cracked.
Y'all are welcome to come
And
here.
shortly after, what they learned and knew after they got her car is that part of her taillight was missing. So at that time, when they were doing their investigation, there was no claim of dog bites. That came months and months later.
Correct.
They went to 34 Fairview and they spoke to the owner, according to witness testimony. And everything seemed appropriate. Concerned, confused, no blood, no scratches, no cover-up, no turned over furniture. There was nothing that would have alerted the police officers that there was any road to follow other than the road they followed. Now they can be criticized for plastic cups or leaf blowers, but that's different. That's different. In order to have third-party culprit under Bowden, the police would have to have known that there was information that targeted or pointed out a different person, and they didn't pursue it.
That's right.
So in the cases cited by both the Commonwealth and the defense, there are a number of cases that talk about information that was known to police at the time they were investigating and they failed to pursue it. That is not this case.
Nope.
That
It is
this
not.
case. There was nothing in any of these proffers that show actual evidence that the police knew of these later third-party culprit claims by the defense, or they knew at the time they were doing this investigation that there was any other lead. And likely the reason was is because there wasn't. The evidence for a reasonable police officer pointed towards the statements, towards the car, towards the light. And that was followed up, which led to DNA in hair and all the other evidence that followed, the data. And so as a concession to the defense, they don't simply get to bring in third-party culprit through Bowden because they failed in the instant case to show a third-party culprit. That's
Right.
not part of their entitlement. And mindful that if they do raise Bowden, whether they get an instruction or not, it is brought. And that means the police, including any police they would call in this case, or we would call, is entitled then to share their state of mind why they did not do something. That can open doors to inadmissible evidence, privileged materials.
Me too.
The state of mind of the officer is relevant if they make it relevant. So we should not engage in a process where we allow witnesses to be asked questions with no ability of the defense to follow up those questions with actual proof. We should not engage in a process where witnesses, their character is attacked when it has no relationship whatsoever to this crime. And witnesses shouldn't be put through the ordeal of defending themselves based on generalizations about supposedly being violent or having a temper. There needs to be that nexus, and it fails. It is beyond feeble. And so I ask Your Honor not to allow third-party culprit in the instant, and you should not allow it as part of Bowden.
All right, thank you. Yes.
Here we go with the nonsense. Everybody put your seatbelts on.
Your Honor, the Commonwealth's motion raises three interconnected issues, not just two. I believe that two of those were conflated by the Commonwealth. I'd like to separate them out.
No, please.
The first issue is the introduction or admissibility of evidence relevant to show that somebody else harmed John O'Keefe. The second issue, which I think was conflated with the first, is whether after the introduction of such evidence, the defense is allowed to argue that a specific person or persons caused John O'Keefe's death. And then the third issue is whether the police properly investigated this matter in light of the information that they had or information they could have obtained or failed to follow up on to show that somebody else caused John O'Keefe's death. Regarding the first issue, which Mr. Brown spent a lot of his argument on, there is ample evidence tending to show that somebody else caused John O'Keefe's death. In our opposition, we have cataloged the evidence against each of the potential third-party culprits that we
That's not evidence.
we were in court. Each one of them had a motive and an opportunity
That's
to harm
not evidence.
John O'Keefe. The investigators in this case had evidence
Speculation
that pointed to Brian Albert. Brian Albert is a violent man. He was not a boxer who punched people in the ring.
Shit shields on.
He was also a violent drunk who sucker punched other police officers. Those police officers are on our witness list. He's been investigated by the.
Ugh. What just happened? Hi? Court TV? What happened? Hi? Okay, it does kick back in. Mike, what the hell? Just making sure. While we're in the meantime, thank you, Kelly, for your $25 donation. I really appreciate you. If anybody else wants to make a donation to the channel, the information is at the bottom of the screen. I really appreciate it. If I'm not reading them, I'm not getting them. And my channel only runs on donations from you guys.
But it exists. It's a live issue at trial. At the time John O'Keefe entered that house, an intoxicated Brian Albert was inside. He had been drinking day and night for hours at a time, and he was liquored up.
No.
He testified to that.
No, he didn't.
Inside when he had his first drink in the afternoon, and he testified under oath he was drinking consistently the entire rest of the day and night. The Commonwealth says that every single person didn't see him in the house. Those same witnesses that the Commonwealth points to, every single one of them also did not see him on the front yard.
You mean the dark front lawn at night?
That he was at the relevant time period.
Idiot.
That day and night, Brian Albert was attached at the hip to his close friend, Brian Higgins.
Oh, please.
This was the night that after having carried on a flirtation with Ms. Reed while she was dating Mr. O'Keefe, Brian Higgins was confronted.
This is not an argument. This is a joke.
And Mr. O'Keefe together. In the words of one eyewitness, Ms. Reed and Mr. O'Keefe appeared to be lovey-dovey that night.
I know.
Higgins had expressed his interest, but it went nowhere. And it went nowhere because prior to January 28th of 2022, Ms. Reed had rebuffed him, essentially ghosted him.
Rebuffed?
Stopped returning his messages. Brian Higgins was liquored up that night as well.
Stop it. She's the
They're
one who
both very
initiated.
large men. The court saw them on the video. Friends who drank the entire day and night, and they were waiting in the house for Mr. O'Keefe to arrive. Mr. O'Keefe ended up dead because he went to Brian Albert's house.
Because Karen hit him.
After Brian Higgins left, Brian Albert maintained contact with him.
I'm
At
disgusted.
2:22 in the morning, the two of them were exchanging phone calls to check in with each other just a couple of hours after Mr. O'Keefe was
Oh,
mortally attacked.
please.
Mr. O'Keefe had dog bites and or scratches on his arm consistent with a dog or an animal attack. Brian Albert had a large German Shepherd who had attacked and injured somebody in the past.
Go ahead. Say it was Chloe. I dare
It
you.
all fits. The Commonwealth utterly failed to investigate Brian Albert as a potential suspect. And I'm sure the court remembers the
No,
words
they didn't.
in a text message of now ex-trooper Michael Proctor, the lead investigator who's now been fired as a result, in part, of being
Definitely a
biased in
clown.
this investigation.
No, not for being biased. Try again for the look of being biased. Try that. Nope. They worded it very
I'll point out
carefully.
Also that when Mr. O'Keefe was in the house, both Brian Albert and Brian Higgins were unaccounted for.
John never entered the
according
house.
To the testimony.
Never
With
entered the
regard
house.
To Michael Proctor's words, he was asked specifically if the homeowner would catch any grief for having a deceased person on his front yard.
And he
Mike-
answered honestly because no, Karen's outside screaming, I did it, I did it, I did it. Why does this keep happening? I'm going to have to switch over to law and crime if this keeps happening. Hold on. I don't know what the deal is with this, but it keeps cutting out. I'm going to see if it's doing the same thing on law and crime. You're just spouting bullshit.
The size of about a thumbnail into a large dumpster. It wasn't enough to throw it in a waste paper basket or a trash bin outside the local Dunkin' Donuts.
John
Instead,
never
he
entered the
went to
house.
Security at a military base.
So I find
and
it
secretly tossed
funny.
this tiny broken SIM card into a
Oh,
dumpster.
shit.
He made sure that investigators would never know what's on his phone, and he admitted to that at the first trial. And of course, the investigators in this case, including the lead investigator, former trooper Michael Proctor, never showed any interest in Higgins' phone.
For
Higgins
what?
nonetheless accomplished his goal of keeping the contents of the phone out of the hands of the defense in this case.
Oh, please.
That's powerful evidence of motive, intent, opportunity, and consciousness. of
You're not
guilt for
getting
Brian
it.
Higgins.
Get over it.
As Mr. Brennan acknowledges, all doubt should be resolved in favor of the admission of third-party culprit evidence,
Nope.
linking him to the harm caused to John O'Keefe. And finally, Colin Albert is a potential suspect. He had been in a
Nope.
feud with John O'Keefe.
For what?
He'd thrown beer cans in his bushes, told him to F off.
Wrong.
We have a good faith basis to claim that.
No, you
This
don't.
is the same Colin Albert who testified under oath he had never been in a fight in his life. Yet there are videos of him clearly desperate.
Clowning
to beat
around
up
with his
others.
friends.
The same
Stop it.
Colin Albert who had scraped up knuckles just a few weeks after John O'Keefe's death. Those
And-
knuckles looked consistent with an attack on somebody. The
Except they
photographs
weren't
that
there
Mr.
after John
Brennan
died.
references that were allegedly before that photo had no metadata. We can't confirm when those were taken. Mr. Brennan wants us to just accept the testimony that they were taken before the scraped up knuckles
They were.
photo. We don't buy it. We don't think a jury will buy it.
They will buy it. But also
John
wouldn't be
O'Keefe
allowed
was
in.
found, he had two black eyes looking like he had been punched in the face.
We know why those
Colin
are.
Albert was at his uncle's house with both his uncle and Brian Higgins, disliking Mr. O'Keefe
Please.
for a different reason, but disliking him nonetheless.
Mm,
And it's suspicious that Colin Albert's name was purposefully omitted out of the police
Your
reports.
face is
There was no
suspicious.
indication in any police report provided to the defense in the first few months of this investigation that Colin Albert was anywhere close to 34 Fairview, his uncle's house, on January 29th. In fact, there's no indication in those police reports that Colin Albert even existed. Initially, we didn't even know who he was. But we found out when we sent a letter to Mr. Lally, while the case was still pending before a grand jury, notifying the Commonwealth that Colin Albert should be called as a witness before the grand jury.
Please.
It was only after we sent that letter notifying the prosecution that we were on to Colin Albert that testimony was elicited that Colin Albert was indeed at 34 Fairview that night. The defense caused this to be revealed, not any investigator of this case. And there's obviously an inference that his name was kept out of the police reports to protect him.
No.
The same way Brian Albert is the only person listed in the initial report whose first name is not even spelled out. He's just listed as B. Albert with an incorrect address.
Because he was a minor. A minor.
A conscious effort of these investigations.
That's why.
Third-party culprits from the
Minors
defense.
aren't named, idiot.
All of these men, Brian Albert, Brian Higgins, Colin Albert, were present at 34 Fairview the night that John O'Keefe was killed, and each had a motive, intent, and opportunity to cause him harm. Now,
Nope.
there are many cases, Your Honor, I know the court is aware of this, endorsing the admission of third-party culprit evidence. Almost all of them allowed in a third-party culprit defense, despite a lack of evidence that the third-party culprit in those cases was actually at the scene of the crime at the relevant time. The first case cited by the prosecution, Como versus Conkey, Middlesex County case, I remember it from the 90s. It was retried in the early 2000s. In that case, a person was murdered inside a home, just like this case. Unlike this case, however, the defense
wasn't
could
murdered
not
inside
place
the
the
home.
third-party culprit at the home when the murder was committed. He lived down the street, and that was enough. Here we have hard evidence, irrefutable evidence.
It's not
that the
irrefutable.
three potential
Colin wasn't even
third-party
there.
culprits were present exactly when the murder was committed.
Not even there.
And it's notable that the defense in Conkey, in that second retrial, after the first trial conviction was reversed, the defense was allowed by the trial judge to present a third-party culprit defense, and it wasn't controversial. But
Yeah,
the
but this
conviction
is,
was nonetheless
because you're
overturned,
lying.
the second conviction on appeal, because the trial judge didn't let the defense go far enough in presenting that defense. The SJC ruled that
Colin
in
wasn't
addition
even
to
there.
presenting evidence of motive, intent, and opportunity, the defense in that case should have been allowed to introduce past sexual assaults of the third-party culprit, including one that took place 7 years before the murder.
It
It
is,
was
freak.
reversible error not to permit a full third-party culprit defense, including prior bad acts of the third-party culprit. And I will ask the court to consider Como versus Finney, a case that I'm very well familiar, as I previously mentioned. I brought that motion for new trial. I argued before the Supreme Judicial Court, and I tried the retrial of that case, so I know it well. The SJC affirmed Judge Ball's allowance of the motion for new trial in that case, ruling that it was ineffective assistance of counsel that the attorney did not raise a third-party culprit defense. The case law makes clear, as Mr. Brennan again acknowledges, that this defense is a time-honored method of defending against a criminal charge. The defense should be given wide latitude to present relevant evidence that somebody else committed a crime. But the main issue in Finney was whether the defense could introduce hearsay to support an already admissible third-party culprit defense. So sort of
hearsay is not admissible.
Where, it's just assumed, yes, of course you can present a third-party culprit defense. But, in Conkey, can you introduce unrelated sexual assaults from 7 years before?
Why is he moving from the podium?
In Finney, of course you can present a third-party culprit defense. But can you also introduce hearsay to support that defense?
Hey, Trisha.
In fact, it was reversible error that the third-party culprit defense was not brought the first time around. Mr. Brennan talks about, well, you can't do this if it prejudices the Commonwealth. That's crazy. Every single time you introduce a third-party culprit defense, you are prejudicing the Commonwealth by definition. You're not going along with their theory of the case. Mr. Brennan's aggrieved that we would deign to present this defense. And I would note, Judge, there's I believe a certain amount of gaslighting going on here.
From you.
One side of his mouth, he talks about he wants Ms. Reed a fair trial. But we've spent weeks where he's just trying to knock out all our evidence.
Because it's not evidence, it's speculation.
More like a defense attorney than a prosecutor.
He is a defense attorney.
Let's
keep throwing shots at him. That's real smart.
Mr. Brennan said that
in front of the judge.
Have third-party culprits who have relationships to the alleged victim and or relationships to the scene of the crime. Faye did not. In Faye, my client was the next door neighbor. My client signed a confession to the murder. The third party culprit lived several houses away.
Yeah, but you had
within the
evidence
same city,
in that case, you
but
idiot.
not close, not next door. There was no relationship other than he made statements about how.
So that's how they're growing so fast.
Oh, for
They're
fuck's
hiring
sake.
freelancers. Look what they're doing with AI experts.
The break from spaghetti.
Picture was made up to me. But there was no, witness that put the two of them together in any way other than.
But
those
there was still
hearsay
evidence in that
statements.
case. There was not here.
Nobody
There
put
is
him at the
none
scene of the
here
crime.
at all. None.
The SJC ruled even hearsay should be admissible to support that third-party culprit defense.
That's
The defense
different
in this
case.
has more evidence of third-party culprits than the defense did in Finney. We're not asking
No.
the court to allow into evidence hearsay,
What?
as was admissible in Finney. We're solely seeking to introduce the crux of a third-party culprit.
The judge
defense,
needs to
which
call
is
them up for
evidence
spread
of
miss,
motive, opportunity, and means.
like lying
All of which
again,
Brian Albert, Brian
stretching the
Higgins, and Colin
truth,
Albert had. That's the nuts and bolts.
like she
of a
said she
third-party
wasn't going to
culprit
deal with, but
defense.
that she continues to deal with.
So that's the first issue. Presenting
You're the
evidence
issue,
of a
sir.
third-party culprit defense. The second issue is whether we can argue in closing that
No.
a third-party culprit is responsible for John O'Keefe's death.
No.
That's an issue I suggest that the court does not need to decide
Colin
now.
wasn't
in
there.
advance of trial. Closing arguments come at the very end of trial. At the charge conference, this court would be in a position and would be entitled to evaluate the evidence as it came in and to make a decision at that time prior to closing arguments as to what we can argue and what we can't. And while we believe the court has enough evidence now as a result of the first trial and as a result of our proffer and our submissions and oral argument today to rule that a third-party culprit defense is permissible, but this court at a minimum should not deny argument on that issue before evaluating the evidence as it comes in.
You don't have
And that brings us
evidence.
to the final third issue of Bowden defense.
Oh God. Here we go.
Obviously, attacking the inadequacies of a police investigation is bedrock constitutional law. It's a bedrock constitutional right.
Bingo, freak.
In this regard, in one
You
sense,
can't.
the discussion about the third-party culprit evidence is somewhat academic as opposed to a practical one, because all of the evidence that points to Brian Albert, Brian Higgins, and or Colin Albert, all of it
So
comes
funny.
in to show the lack of investigation, the lack of curiosity that the police had, and the lack of investigation that they did to rule any of them out. And it comes in to show the bias of the investigators of this case. Bias is also a constitutional right. They were perfectly willing to jump to conclusions about Ms. Reed, someone outside their law enforcement circle on the wrong side of the blue wall, but very much unwilling to be curious about whether someone within their circle had the motive, opportunity, and means to hurt John O'Keefe. Former Trooper Proctor specifically told his friends he had no interest in investigating someone connecting with law enforcement.
Hank does get the
And
last
in
say.
their internal affairs findings, his superiors.
Turtle
Turtle
affairs?
Bias was one of the reasons he was fired.
No.
Can't have a stronger Bowden defense than that.
His
So
look of
I would
bias,
argue,
not
Judge, that
actual
the Commonwealth's
bias.
motion really comes down to what the defense will be able to argue in this case.
He
Our
wasn't.
position is we should be able to point the finger of guilt at those who might have done this, but at a minimum, given that the evidence will be coming into trial anyway on the Bowden issue, the court should reserve judgment on what we will be allowed to argue from now, weeks from now, when closing arguments are upon us. This evidence, in conclusion, in our view, must come in. This is a due process constitutional right of my client, and it has to be admitted for two reasons. Number one, it's a time-honored method of defending against a criminal charge by pointing out that somebody else could have done this.
Who are these
And number
clowns
two,
just walking
it's a
in?
time-honored method of defending against the criminal charge by pointing out that police investigators failed to do their jobs correctly. We have a stronger third-party culprit
can't.
evidence situation here than existed in either Conkey or Finney. And we assert it would be reversible error for this court to exclude this evidence. Unless the court has further questions, I would rest.
Yeah, the question is, where's your evidence? That was a terrible argument. It's nonsense. You have no evidence to prove third party. Go ahead, Hank. Do your thing, bro.
I'm going to choose to focus on case law
Yep.
and the facts that aren't presented by the defense.
Yep. Do it. That's what I would do.
We see in their motion there's a grand claim that there's extraordinary evidence that John O'Keefe went into 34
Where?
surgery that night. That is
Where?
critical. Because there is no basis to accuse somebody
He did.
of murdering another person
He
if they
did.
don't have the opportunity. In other cases, a third-party culprit is not necessarily found at the scene, even in Finney. It's more than just a couple derogatory words. In Finney, as counsel knows, there was a neighbor who had an axe or a club. He was seen with blood, went home, washed his clothes, wholly irregular. And because of this irregularity and the timing, he was then asked by his then wife about the victim, and he made a number of derogatory comments about her, showing ill will, evidencing, tangentially, motive. And so, no, a third party does not necessarily have to be at the scene at the time the police investigate, but they have to be with the deceased if they caused the death. It's obvious.
Boom.
And so we didn't hear any extraordinary evidence, none. We didn't hear kind of good evidence. We didn't hear any evidence. We just have the bald assertion that the data forensic evidence will show that he was in the house. It didn't. It doesn't. They don't have a proffer. So there is no opportunity to murder John O'Keefe when all the evidence points to him dying on the front lawn from an alleged collision. The defense's effort to tell a story. Take a couple of facts. Someone's a
story.
boxer, they drank alcohol, and convert it into a story is how they will try to portray these unsubstantiated facts at trial. They'll tell a story. It will divert the jury's attention. So they're not entitled to it. They're not entitled to it. Time-honored tradition, yes, but there are limitations. Silva Santiago was very clear about the limitations. This latitude is not unbounded. Each of these limitations recognizes the admission of feeble third-party culprit evidence poses a risk of unfair prejudice to the Commonwealth. I'm not whining. The Commonwealth should not be unfairly prejudiced. The people of the Commonwealth should not be unfairly prejudiced because it is inevitably, it diverts jurors' attention away from the defendant on trial and onto the third party. Essentially, it requires the Commonwealth to prove beyond a reasonable doubt the third-party culprit did not commit the crime. If there was evidence of third-party culprit, the defendant should be entitled to use it. In this case,
They don't.
there is not. There is no motive.
Correct.
There is no motive. To suggest that one person was pining, although the text messages don't show that, they both stopped corresponding with each other days before. To suggest that Mr. Albert is friends with Mr. Higgins and therefore he is bootstrapped into a conspiracy to kill with no evidence. Certainly the defense can infer certain facts like getting rid of the SIM card in a way they want. And I don't begrudge that at all. There's different interpretations to it. I understand that. This was heavily considered in the federal investigation. And after that absolute thorough investigation,
nothing.
There were no charges. There was no evidence of third-party culprit. There were no indictments. And so, although we don't know the parameters of the federal investigation and we can only guess as to some of it, we know from what we did receive in review, it was thorough. And if there was third-party culprit evidence, we would expect that there would be a basis for it. It's not an entitlement to simply bring it in under Bowden. I don't defend that there was commentary in the officer's phone that was inappropriate. But that doesn't automatically create a situation where there is evidence that the police officers knew that there was somebody that should have been investigated. In fact, when Mr. Alba came down the stairs, the testimony is the police officer was already inside his home. There's no evidence Mr. O'Keefe, a first responder, was still outside that aid could have been rendered. That is just, it's not only speculative, it's just piecing together different facts and telling a story. So inevitably, while I recognize the case law, there are plenty of cases that talk about third-party culprit should not be admitted if inappropriate. Commonwealth v. Stedman. In that case, a person, not the defendant, was in a fight with a person at a campsite. And then later, the defendant supposedly went back to the campsite, a friend of this person, Royal, and used a knife to stab and kill him. And the defense wanted to introduce prior convictions about the fact that this supposed third-party culprit had attacked people at other homeless sites. Pretty close relationship. A person having a history of attacking people at homeless tent sites. And the court, looking at 403, did not allow it as third-party culprit. They said that the admission would be feeble, pose a risk of unfair prejudice. In that case, there was third-party culprit admitted pursuant to Bowden in a very different way. Commonwealth v. Moore. The court would not admit layered hearsay showing different identifications that were relayed by the police from third parties regarding a culprit. They said that the hearsay was uncertain, the source is unreliable, and it was inadmissible as third-party culprit. So it is not an entitlement to be third-party culprit. Commonwealth v. Buckman, 461 Mass. 2011. The defendant was charged with murdering his wife. When they received a report from one of the defendant's friends, the defendant was softly tied to a pole that looked like he had been kidnapped. Inevitably, the police determined that he had help or tied himself as a ruse. And this person, the helper, his friend, had connections to gambling, was there, and when the police couldn't find the body, he knew exactly where the body was. That case is far stronger than many. And in that case, no motive, no intent, and they did not let a third-party culprit defense go forward.
Stuck in a difficult roommate situation
Sorry.
and an even worse credit situation? Good thing there's self-free rent report.
Not here in this case. And again, I iterate my position on denying the defense to cross-examine witnesses about these generalizations and these character attacks. I think it will mislead the jury and it will become a total diversion for the jury.
Yep.
And I don't think the basis is anywhere close. It's feeble.
Yep.
That briefly respond? Thank you. First of all, Your Honor,
Oh, God.
speaking about the federal investigation, when you were not a part of it, and talking about why a federal grand jury was convened, what they were investigating, what they found or didn't found, is complete speculation. It should not be a part of
Oh,
this
but you're
document.
speculating.
We don't know.
You've been speculating
It's not as though they
for a
came up with
year
statement
for you.
anyone.
So stop
that
it.
should not be considered by the court. With regard to the two cases that Mr. Brennan cited, you'll note that in one, he talked about the exclusion of hearsay evidence. There's a different standard when you want to introduce hearsay evidence as part of a third-party culprit defense. There need to be substantial connecting links to the crime itself. The court ruled in that case there weren't. In Finney, there were. And with regard to the other case, that's with regard to hearsay. With regard to the other case, that was the exclusion of past assaults to show that somebody was violent. Again, Commonwealth v. Conkey is a case where they said, well, that should be, in addition to a normal or a regular third-party culprit defense, you should also be entitled to that evidence. So that's not very instructive. The other two things I just wanted to point out, because I did not mention them, Your Honor, is that Brian Albert also disposed of his phone. We'll never know what was on that. That's further evidence of consciousness of guilt. And then an important point is that the plow driver, Mr. Laughlin, went by the house at 3:30 in the morning and saw a Ford Edge parked in the very area where John O'Keefe's body was found. And we know from the evidence that the Alberts, both Brian Albert and Colin Albert, owned a Ford Edge. So that is in the mix as well. And unless the court has any questions, I would yes on that.
Hi, thank you very much.
Thank you.
So let's go on to paper 620, the Commonwealth motion for production of records regarding unsolved productions.
Ma'am?
Yes.
Your Honor, the Commonwealth filed a Rule 17 motion for records from unsolved productions. It has been discussed briefly in court at times during argument. There was a so-called documentary that was aired in a 5-part series. It gave a inside, behind-the-scenes look of the defense team and Ms. Reed as it prepared for the last trial. This 5-part docuseries produces a number of statements from the defendant, many of them extraordinarily relevant, some of them from the Commonwealth's perspective extraordinarily incriminating, and many of them inconsistent with statements made publicly in the past, including Dateline 2020 into Gretchen Voss. We served the local service in Boston, a local agent. The record holder is the producer of the series, and they have been notified. If the court allows this motion, I expect they will provide the information to us by the end of the week. I understand there is probably over 200 hours of recorded interviews, and we expect to use a number of those statements at trial. They are statements of the defendant, they're admissible substantively, they're admissible as admissions, and they're admissible to show contradictions with other statements. And so they are material and relevant. I understand the time frame. We haven't had the privilege of seeing them. The defense was there for a part or most of it, but we will use the time we can to sift through. We're not looking for a continuance or additional time to look at the materials. We'll look at them as we prepare for trial. And so I'm asking you to grant this. It clearly makes the Rule 17 standard material relevant. We don't have access to these before trial. We won't be able to prepare for them if we get them pursuant to a trial subpoena. They've been properly subpoenaed and they're forthcoming with a court order.
There's no one here from Unsolved Productions opposed to this.
There is not.
Does defense want to be heard now?
Your Honor, we're unaware of the communications back and forth between the Commonwealth and the production company. So we've not been privy to that. This is the first we're hearing of any communications that they've had with the production company. I think obviously in an abundance of caution, they should be given an opportunity to oppose if they wish. Nothing officially has been filed one way or the other. So we're not in a position to argue on their behalf, for sure.
All right. I think we're going to do one second. So, there's two things left to discuss. I want to talk about jury impoundment. We also have a Commonwealth motion regarding Mr. Yannetti's claim. Mr. Yannetti, it's 12:10. Which one do you want to go forward on first? Do you want to talk about the impoundment, or do you want this motion?
I'm not going to leave you with those.
I understand, but do you have a preference with them before lunch? All right, so let's do that motion. Commonwealth's motion to compel communications between the defendant and attorney. Stored within the defendant's.
Here we go. About Yannetti's phone. Here we go. Go, Hank. Go, Hank. It's not your birthday, but thank you for the $10 donation, Anna, from the House of Beaver. Appreciate you.
So I'm clear, the Commonwealth is not seeking all communications between Ms. Reed and Mr. Yannetti. We're only requesting the communications that may be on any type of records in the possession of the Commonwealth. And specifically, there are phone records which have been redacted, and I do not know was underneath those reactions. And we believe we have an entitlement to the information in the narrow area where Ms. Reed has waived her attorney-client privilege. Specifically, where the defendant intentionally divulged the content of her communications with Attorney Yannetti about liability and potentially striking John O'Keefe with her car.
Yep.
Those subject areas in that narrow time frame are no longer privileged because they're now public.
That's right.
The Commonwealth has identified a very narrow window, and that's a 3-day period. And that is what is mentioned by Ms. Reed in her public statements, that she spoke to Mr. Yannetti and she thought about it for 3 days. We're not looking for any information beyond what has been waived. We're not looking for any information on collateral issues, and that's why we suggest that the court look at those records in camera, and the court makes the assessment whether or not the area where Ms. Reed waived her attorney-client privilege, whether any of those materials would similarly be waived because they are exactly related. This is made in good faith. Anything that is non-privileged is open to the public. It's not confidential. There are 2 communications that Ms. Reed made publicly that we assert waived the attorney-client privilege as it relates to that issue. Ms. Reed had an interview with Gretchen Voss on June 20th, 2023, and the transcript is page 105, line 23. She was asked the question by Ms. Voss, "You never said, 'Did I hit him?' I hit him." And the answer by Ms. Reed was, "I said, did I hit him? Question mark. And then, when I talked to David, now this is later, David said, 'Karen, if you incapacitated him in any way, there's culpability there.' And I thought, all right, maybe this is maybe I said to my mother, just to go forward for a second, they were asking me, what was it like? Did they come out? What was the house like?" Similarly, in the documentary series, Ms. Reed is video and audio taped, and it was presented on television, that she said, "And then when I hired David Yannetti, I asked him those questions the night of January 29th, like, David, what if I ran his foot over, or what if I clipped him in the knee and he passed out or went to care for himself and he threw up or passed out?" And David said, "Yeah, then you have some element of culpability." So that's how I thought about it for about 3 days. And so that is where I get the time period regarding these relevant statements, admissions by the defendant about her state of mind and her interaction with John O'Keefe and her vehicle. These statements were made during conversations that are obviously no longer protected or private or privileged. They're no longer confidential because they've been intentionally disseminated to the public. And so the defendant has voluntarily waived that privilege as to these communications in this subject area in that time period. And the key, Your Honor, is that it is the defendant herself who made the communications confidential. Even if it was inadvertent or overheard, it would still waive the privilege. This is entirely different. There can be no doubt that there was an intention to pierce that attorney-client privilege for whatever benefit the defense thought it gained them. If this was intentional, it wasn't secretive, it wasn't overheard, it was a exacting and purposeful engagement. So we ask you to review the cell phone extraction, any texts or emails that may be on those extractions, and relative to that short window, relative to this specific area, anything that is waived that is no longer confidential, we believe we're entitled to. It obviously would be relevant if it's narrowly related to these statements, and we would use that at trial.
Lemonade Renters Insurance protects you from life's coulda, shoulda, wouldas.
Sorry.
I coulda hired a plumber. Shoulda.
No! Fuck! No! Did Alessi just said I am? Oh, you guys. Oh, I can't. This is so painful. Oh, thank you, Potluck, for your $15 donation. I appreciate you. If anybody else wants to, there's a ticker
Please the court.
on the bottom of the screen.
Commonwealth concedes throughout its motion, as it must,
that
the communications it seeks to intrude into are privileged communications between Ms. Reed and her attorney, Mr. Yannetti. Two of the three instances of the communication they cite to are over 9 months old. And that's in 5 months old, respectively. So you have 9 months ago, the Gretchen Voss statements, and 5 months ago, the Vanity Fair statements.
So it doesn't matter when they
waited
happened.
Until less than 2 weeks before the start of the trial.
Doesn't matter when they
this
waited.
Momentous and potentially far-reaching and consequential motion.
That doesn't matter. Doesn't matter
the
why.
The courts are clear.
They have the right.
They take an extraordinarily dim view of parties waiting until moments before trial to raise significant issues like privilege communication.
They have the right.
This close to trial.
And you guys did it a million times.
The Commonwealth does not explain their delay in raising this issue.
Doesn't matter what the delay was. They have that right.
With regard to the third communication.
Sorry.
The HBO Max.
That's not an argument.
It regards the same event that is discussed in the first two. There is no addition of an event in the third one. So that third discussion, the docuseries, regards the same events that have been extant in the first two that have been extant for 9 months.
But that was her ultimate waiving. Now it's not a mistake.
Attempted
Idiot.
Intrusion by the Commonwealth should disturb and unsettle every citizen of this Commonwealth.
Oh, save it.
Because they're either actual or potential clients of lawyers, and it should unsettle every criminal defense attorney in this Commonwealth. And I would dare to say it probably does.
Yeah, you definitely have time.
As we know, texts, emails, and written communications, exactly what the Commonwealth is seeking here. Between an attorney and their client.
So Turtle looks afraid.
Canonical examples of privileged material. So what is at stake in this motion? What is at stake is the sacrosanct attorney-client privilege. In Upjohn versus United States, the really bedrock attorney-client case from the U.S. Supreme Court
looks uncomfortable here.
It established that dating at least from the age of Shakespeare, the attorney-client privilege is the oldest privilege for confidential communications known to the common law. And this Commonwealth has identified that it is one of the most important.
She waived it.
Recognized in the Commonwealth.
She waived it.
1831. And in the context of criminal circumstances, the privilege has constitutional dimensions as well as it affects the interests of justice analysis that is documented in the Commonwealth v. Goldman case 395 Mass at 502.
Guy.
And it
she waived it.
Underscoring the basis and the depth of the intrusion is a quote from the very case and the only case that the Commonwealth cites in its motion. It cites one case in its motion for all of its propositions. Just one. Matter of a John Doe grand jury investigation 408.
You guys, doesn't matter how many they cite.
In the case at 485 states, as we have indicated, extraordinarily high value must be placed on the right of every citizen to obtain the thoughtful advice of a fully informed attorney concerning legal matters.
It's got a rotary cut.
Permit or require an attorney to disclose information given to him or her by a client in confidence, even though such disclosure might be limited to the period after the client's death, would in many instances, we fear, so deter the client from telling all as to seriously impair the attorney's ability to function effectively. We think that the potential is inconsistent with the traditional value our society has assigned. Here's a key point. In the interests of justice, and that's the rooting of the interest of justice.
She waived it.
To the right to counsel and to an effective attorney-client relationship.
She
Therefore,
waived her
except
privilege.
where mandated by constitutional considerations, and it cites the Commonwealth v. Goldman, Super 395 Mass at 502, which are not a factor in this case, nor are they a factor in our, not a factor in that case. We conclude that the attorney-client privilege should not yield either before or after the client's death to society's interest, as legitimate as we recognize that interest in obtaining every man's
blah, blah, blah.
The case the Commonwealth cites supports the protection of the attorney-client privilege.
No, it
With
doesn't.
that law jurisprudential predicate in mind, I now turn to the statements at issue here, and
we should have started with that.
To that analysis.
Dumbass.
Mr. Leslie, I'm going to stop you.
Please do. Thank God.
I understand the Commonwealth's argument regarding waiver. I understand that the request is narrowly tailored. I'm not going to give you this information, Mr. Brennan. I don't even think it's appropriate for me to have so the emotions.
What? I knew she would say his motion was denied. She waived the privilege. It's solid legal ground. He should have them, and I have no doubt that he will offer a motion to reconsider. Yeah, she stopped him because she denied Brennan's motion for them.
We need to talk about the panel. The parties need 5 minutes.
She denied Brennan's motion for the communications. Hold on. All right, well, there goes the judge anyway, but she denied Brennan's motion for the communications with Yannetti, which I think he will probably file a motion to reconsider because it absolutely 100%. We'll go back, but what she basically said was she stopped Alessi from arguing it because she wasn't going to give it to Brennan and ruled on it right there, not even thinking about it. Which she's given the defense 1 billion times over to think about it. Like, oh, I'll think, take into consideration. She didn't. I'll go back. But that was the stupidest thing I've ever seen. Not that she hasn't done stupider things than that. Karen clearly waived her right. And yes, attorney-client privilege is very, very important, right? But she waived it by talking about it 72 and a half fucking times on national media.
Mr. Leslie, I'm going to stop you. I understand the Commonwealth's argument regarding waiver. I understand that the request is narrowly tailored. I'm not going to give you this information, Mr. Brennan. I don't even think it's appropriate for me to have so the motion is denied.
She doesn't think it's appropriate.
Thank you, Your Honor.
She understood it was narrowly tailored, that the Commonwealth was narrowly tailoring what they were asking for, but that she was going to deny it anyway, which I ultimately think is a giant mistake. I don't think she really had the right or the legal ground to do that because he was on sound legal footing when it came to this. Like, she waived it. And the reason that he waited, as Alessi was bitching about how much time had passed, blah, 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 is because once you can say it was a mistake, right? Twice you can say was a slip of the tongue. But 3 times and on national media, you cannot say that she didn't know what was going to happen and that might not be asked for. Now, basically, you just told every defendant in Massachusetts that they could just talk about all the communications that they have with their attorney, and they will never, ever be allowed in a trial, and that you can't waive them. That's what she did. Like, that's crazy talk. That's absolute nonsense. Like, that's absolute nonsense. I'm sorry. But once again, the judge has done exactly what she shouldn't have done, which is given to the defense in their BS, because they absolutely had every right to that. She absolutely waived it by talking about it numerous times. You know what your privilege is. So if you're going to talk about it, you know that you're now possibly waiving that privilege, especially when you know it's a national media channel that's going to be broadcast to the world. Like, come on, man. Like, ridiculous. Like, I get it. I get that. But at the same time, again, he was asking for very narrowly tailored information, and she waived it when she talked about it numerous times. Like, she does lean heavily towards the defense. She was a defense attorney, but it just gets me because, like, do what's legally right, not what you're worried about appeals, not what's heavily defense leaning. She's allowed them to go around with this circus for how long? And I almost wonder, though, if in her head, she already just decided that she's not going to allow them third party. So if by allowing this, that she was going to say, oh, I have to deny this one, because if I'm not allowing defense to do third party, then like it kind of looks, she's too worried about what it looks like, right? She's too worried about the optics. Like, fuck the optics. It's what's right and what's not right, what's legally supposed to happen, what's not legally supposed to happen. The optics don't fucking matter. And I'll say that the optics have been a big part of this entire case, not just with Karen, but with the Sewer Turtle as well, where the police have literally said, well, like, oh, we're not going to do anything about that because like it would cause a melee, like basically, like we don't want to deal with his mob of people. Like, that's not the way the justice system works. It doesn't work on optics. Okay? That's not the way it's supposed to work at all. Not even a little. Like, ridiculousness. Like, oh yeah. That's what they do, right? Is whine and bitch and cry. And they'll say, oh, the judge did the right thing here. And then, God forbid, she say no third party. They go back to she's in on it mode. That's what they do, you know? Like, I just don't understand why. She has different answers in every one of them. Like, he could come back with an even narrower, just the 29th and just that. I still don't think she'll give it. Like I said before, I don't think she was going to give it to begin with, but it's just not okay in my opinion. Bottom line. Like, oh, we will be streaming the second trial. Right? I thought about it. You know what I'm saying? If she says no to third party, it's a wash. You got one. And you know what I mean? Like, it just doesn't make sense. Like, I don't know. I just wish there was a different judge that we had from the get-go, because a lot of this shit would have never happened. You know what I'm saying? There's a lot of things that wouldn't have been allowed. The defense wouldn't have been allowed to spread misinformation as long as they were with another judge. They wouldn't have. All the lies, all the stretches, all the mysteries. They have about zero evidence, as I said before this started, zero evidence of any of the three people that they named as third-party defendant to even name them as third-party defendants. Yes, they're on lunch break. So, and I don't know why they're on lunch break at 12:30. Because I heard her say something about before lunch. It's 12:30. So why are they going on lunch break at 12:30? Whatever. Either way. That's another thing. She knows damn well he's going to put everybody to goddamn sleep. Like, it is. They do have the interviews, but they're only going to be able to use those interviews if they can get the uncut portions. That's going to be a huge barrier, which is what they're trying to do right now. But that means that each one of the production companies has to be given like a time and a place to come into court and argue on whether they want to give it up or don't want to give it up, have the judge rule on whether they have to give it up and whether they don't have to give it up. It's a whole thing. So that's what, the defense was arguing earlier, is like, there's nobody from that company here right now to argue against or for agreeing to giving it or not agreeing to wanting to give up the information. So I think, of course, most of the time they're going to fight because they're journalists, so they're going to fight, but there's no journalistic privilege in Massachusetts. It does not exist here. Yeah, a lot of us read them. Like, she gave them to Aiden, like, or he gave them to someone, and so on and so forth, as we know. Like, oh yeah, a lot of us knew long before Investigation Discovery did. A lot of us knew a lot of this stuff long before a lot of these documentary series came out. We still know quite a bit of things that the public doesn't, and that none of these documentaries do, which is a damn shame. But to be fair, if these documentaries actually decided they were going to speak to more than just free Karen Reed people, maybe they would have found out some of that information, but it's who they chose to talk to, so that's on them, Oh, I'm going to show the photo. I got to get into my Gmail to show it. So while all that was happening, we had some interesting other thing happen. I'm going to get it on my screen. I just got to get into my email to do that. So give me 1 second. And also, again, just because it was while, the thing was happening, I want to thank Anna and Potluck again for your donations, for the $10 from Anna and the $15 from Potluck. I appreciate you guys. If anybody else wants to donate to the channel, we are just a very small channel, and the only way we stay afloat and bring you this content is from our donations, from our viewers. So the ticker is on the bottom of the screen, and you can do it Cash App, PayPal, Venmo, and we really appreciate it. It's always super helpful to help cover costs. Okay. And we're like a family here. I love this community. So for those of you who have just joined us, I think that you will find that this is a community that you will love being in. Everybody's super nice. We always get some great one-liners. Even when we get super, super mad that something stupid happened, someone always makes us laugh over here so that we can process together. And I love that. So let me see. Let me get this up on the screen here. So, all right, let me do this one first. Hold on. Boop. Can I make this bigger? Oop, I can. All right. So I won't. So it looks like from inside the courtroom, I will try to blow this up as big as I can in a second. But it looks like, that's a damn good question. The judge used to be a defense attorney way back, years and years and years ago. She was worked for the public defender's office on some cases. But it's a good question, Kelly. She is, unfortunately, but there are lots of judges that wouldn't deal with this bullshit. Okay, so you are not unemployable. Stop that. Listen, if I owned a company, I would hire half of you because you guys all are amazing at something. If I ever, and I've thought about it, Anna, if I ever start my own blog or my own website, which I've thought about doing lately, I'm going to need some writers, right? And so I got a couple of people off the top of my head that I know that could write beautifully some articles. All right. I'm going to blow this up a little bigger, but what it looks like happened was, this is Kevin's stream, I believe. Ashley was in Kevin's stream, and it looks like Aiden here, this little chump guy here, this sewer turtle guy here might have possibly been, as you can see, it says, shout out to my fans. And this says Turtle Boy Live. But then it gets deleted. So obviously these are not fans of his. They're on Kevin's channel. So they're not fans of his. And then he deletes it. So I don't know if we have no way of knowing, since he deleted it, whether it's him or someone pretending. Most of the time though, when you use that name, there isn't a way, when you put a name, you have to change it in a certain way for it to to try to mimic someone else's. It has to be different in some way. So this is what it looks like he did, because Ashley tells me, Ashley's here now, that it gets deleted right after. Now, this is while he's in the courtroom. So this is why he looks so perplexed all the time when he's in the courtroom. He's like, because he's doing stuff like this. He's not actually paying attention to anything that's going on inside the courtroom. He's more worried about what's happening online. And let me make something abundantly clear here. This is all the man does. 24/7, online. His life is sock accounts and online. That's all it is. So, like, he can't stay offline even inside the courtroom with a press pass. You know, like, it's kind of sad. Like, so it's like, what is actually happening? They just went on break, so I'm not sure, but I have it up on a screen back here so that when it does pop back up, we will know about it. Oh, I think it's back. Hold on.
Number 5 on the first page. I don't like the 2 questions in a row, 4 and 5. I don't think we need 5.
Questionnaire.
Is that okay with you, Mr. Brennan?
Let me back up just a smidge here. Oh yeah, that we just came back. So basically she's saying she doesn't like questions 2 and 5 together.
Is that okay with you, Mr. Brennan? I don't think we need both.
It's redundant.
Yeah. So that's out. So I'll go through, actually, I'd like to go through the first page of each. The first page of the defendants, number 13. Do you believe law enforcement officers are generally fair and accurate in their investigations? Who's arguing this for the defense?
I can argue it.
All right, so I don't have a problem with that, but it makes sense that we put it after 8, those series of questions.
No objection to that.
All right, any objection to question number 13 and putting it at 9, Mr. Brennan?
I don't have any objection to moving it after 9. I think it's a bit one-sided. It leans towards, one-sided, but I don't have a strong objection to it.
We can balance it if you want to suggest some language.
If there's an invitation to balance, I'll need a moment.
All right, so you can suggest something at some point. All right, so now moving on to the second page. The Commonwealth's number 17 seems appropriate to me, but if you were working for the same document, it's not in the defense when it was removed, I guess. Is there anything about crash reconstruction testimony that would make it difficult for you to be fair and impartial in this case? I don't have a problem with that question. Does the defense?
We didn't have a real objection to it, it just wasn't a particularly useful question. We thought at the last trial, everyone said no, so in furtherance of trying to have additional space for more helpful questions, we just decided to exclude it.
All right, I think we'll keep it. There's one I do want to get rid of that caused problems last time, but we'll talk about that in a minute. All right, so thank you. So, question number 23 on the defense. Does the Commonwealth object to that question? I think it needs to be tweaked at the least.
We do.
All right, so what's the objection?
I think the question, the way it's written, invites a juror to potentially not follow the judge's instruction. And so I understand the attempt, the idea of it, the germ of it, but the way it's written, it invites, I think, a jury to, or a juror to.
Now, with Lotto.com, any stolen second, any casual, mindless.
I think if we just tweak the language a bit, I mean, we're happy to hear some proposals from the DA as to sort of the particular issue to have this question. But I do think a question about the judge's instruction regarding, you're entitled to your own independent individual verdicts.
So they're always told that their verdict must be their own. So there's language in there's probably language in my preliminary instructions, there's language in the charge, certainly. So if it mirrors that language, I don't have a problem with it.
Yeah, I have the questionnaire.
Otherwise, I might, so
We can mirror the
talk to each other about that.
charge.
All right, so,
We would agree to that as well.
okay, thank you. Number 25 are defendants. If you had to vote today on whether Ms. Reed is guilty or not guilty of the crimes charged, what would your vote be? I tell them throughout the trial, they're not to speculate, they're not to make up their minds until all the evidence is in.
Nope.
I'm not going to even suggest that this is appropriate. So I'm not going to include that. There are enough questions on reasonable doubt, presumption of innocence, and defendant not testifying. So that's out. So the question, also, is there any reason why you do or do not want to serve on this jury? I don't think we should invite them to decide whether they want to sit in this jury or not. I think we did give this last time. I don't know what the responses were. Does anybody have any information on that for me?
I think most of them were no. I think 27 kind of hits the same sort of, if
Right,
you have
if that-
more concerns about the case, so I don't have a strong objection.
If that's what we're getting at, we've got it in 27. So I'm inclined not to put it on there. Again, I can hear from you beforehand, probably in writing, I don't want to bring it back.
I'm writing them down.
There's two on the first page that were slightly worded differently in the Commonwealth proposed questionnaire and the defendant's
Oh, okay, which
proposed
numbers?
questionnaire. If the court looks at number 4 on the defendant's questionnaire, we had kind of combined the Commonwealth's proposed questions 4 and 5.
Yeah,
So there's one question.
so that's, and I just got rid of Commonwealth 5.
Perfect.
So this one's better, so we will use that.
Okay, and then number 7 that was proposed by the defense, that is the same, similar question as number 8 in the Commonwealth's proposed questionnaire.
Yes,
It's just different language.
I thought it was the same.
So we changed it to say, would you tend to believe or disbelieve law enforcement
Tend.
officers?
Thought you don't use
firefighters,
tend.
First responders more than a civilian witness simply because of their occupation, as opposed to automatically believe.
So we typically ask the automatically, what's the Commonwealth's position on this?
I have a strong preference on the third court.
All right, so I will think about that, Ms. Hamel.
Thank you.
All right, so the question that I don't like, and you may remember, causes a lot of jurors to say, I have no idea what you're talking about. 21 on the Commonwealth, 20 on the defense. So you may find the defendant guilty based on circumstantial evidence, but you cannot find the defendant guilty based on speculation, guesswork, or surmise. Is it difficult for you to understand the difference between circumstantial evidence, speculation, guesswork, and surmise?
I'm sorry, can you repeat that?
It's your number 20. I'm not gonna read it again.
Yeah, like shouldn't have to. You should be paying attention, dude. Come on. She is
Caused a lot of
useless.
trouble before. I think in every single one, I had to repeat myself with the instruction that I gave in anticipation of this. I gave them a pre-charge on circumstantial evidence and not being able.
Yes, just the way that it's phrased in the Commonwealth's questionnaire makes it seem that the Commonwealth doesn't have to meet their burden of proof.
I think it should be omitted completely.
I have no issue with that, it's just the way that it's
Does the
phrased in the
Commonwealth-
Commonwealth's questionnaire.
It's just confusing in my mind.
Okay, they took out, if you remember, it took out an inordinate amount of time, virtually every single juror.
We have no problem with that.
All right, so that would be omitted.
Omitted.
Right, so that's that. Ms. McLaughlin, I think you said, and I think I cut you off the other day, that the third page.
The jury is left after this. Impaling the jury.
95 pages of it the other day, and I didn't see it. Where does this third page come from? The publicity.
The questions come from Chisholm, that were asked in the juror questionnaire. The other, some of the other cases, questions were part of the juror questionnaire in the prior trial that just moved over to this page. So this page dealt with a questionnaire exclusively on profile publicity.
Okay. All right, I think that we all know many, if not most, and perhaps all the potential jurors. have heard about this case, giving them the opportunity to write the details that they would call down may take an awful lot of time and space that we don't have on this form, and frankly, I don't.
We'll get those
So.
like every day we
what are
might
your
get
positions, what's your position
some,
on 3?
Eva.
Eric, I may, I can just hand up the excerpt from the Chisholm case that outlines the.
All right, I'm not sure 2 lines are enough space for it, frankly.
You're welcome,
All
darling.
right, I guess we'll see what we can do. I didn't realize it came directly, same language. Okay, looks like we're giving this 3rd page of the questionnaire. Yes?
Yep.
You
3rd
are
page.
To the court's attention, something about, the court and counsel just discussed question number 7. Could I ask the court to direct its attention to
All right,
question?
which page?
Sorry,
Current page or previous page?
the defendant's questionnaire on the 1st page. That was the question. I think the court's going to consider whether to use the word automatic or tend to.
Yeah.
I believe that should be broken into 2 questions. It doesn't tell us anything. For instance, the way it's written in the disjunctive, would you tend to believe or disbelieve law enforcement officers, firefighters, first responders more than civilian witnesses, just simply because of their occupation? If someone says yes, we don't know if that's believe or tend to disbelieve. So I think if we just break it into 2 questions and now we've got the space to do it, that would be more instructive.
Why does it matter if it's an automatic?
I'm not worried about the automatic part. It's the believe or disbelieve. That's the part that doesn't help us.
Right, so if it's automatic, simply because of a person's occupation, this juror would automatically either believe or automatically disbelieve. How does it make that person a juror? Why do you need it?
Because that tells us, it would instruct me at least, it would enlighten me on how to further question that juror. If someone says, well, I'd automatically disbelieve police officers, or I'd automatically believe police officers. Those are 2 very different mindsets.
So I understand that. I'll consider it. I think we keep it as 1, and then if they say yes, we inquire.
Yep.
Maybe. Let me see.
Okay, thank you.
All right, so it looks like we have the 3rd page as well. I think, I have the statutory questions that I would ask of the Nairi. If we take that question that Mr. Jackson just talked about, I can ask each individual juror, if I use the tend language, if the testimony were in conflict, would you tend to believe the testimony of a police officer more than any other witness simply because he or she is a police officer? And then conversely, would you tend to disbelieve a police officer simply because he or she is a police officer? I typically do that at sidebar in every case, asked exactly like that. So it makes more sense to me that we do it that way rather than a questionnaire. But if you wanted a questionnaire, we'll stay as is. So what's your thought, Ms. Lynn?
That would be the defendant's preference.
Do you care, Mr. Byrne?
We prefer a questionnaire.
All right, so I'll think about it, I'll do it one way or the other, and you'll know next week. So one of the things that I was considering doing, so we have a lot of jurors coming in next week. On Tuesday, 218 jurors have been summoned, is my understanding. We will get some portion of that, we will get some fraction of that maybe, just on how it goes with whether people
Maybe.
are here and available to testify on that date. To serve as jurors. So say we get like 150 or 175 jurors. I have my remarks to sort of just direct them to what their job is, as you remember, and then I leave and I give them the questionnaires. My guess is for the jurors to fill out this questionnaire, have the questionnaires collected and copied might take an hour and a half or 2 hours if we have a really large number of people. What I intend to do, at least on Tuesday, is have all the jurors fill out the questionnaire, however long it takes. And depending on how many jurors we have and what time it is, maybe take 50 of the last jurors or so, send them home and have them come back the next day at 11 o'clock. If we've got fantastic court security here. Hopefully we've got a courtroom to keep people in. There are a lot of things we have to juggle to get this done, and I don't want to waste jurors' time. So I would send them home.
You're wasting our
have them
fucking
come back
time.
The next day at like 11, so that then the next day's jurors at 11 o'clock can spend that hour and a half, 2 hour process, filling out the forms, having them copied, given to counsel, and we can continue on with those jurors. So it's something we can decide on Tuesday when we see how many people are here, how many jurors we get, how many jurors the district court needs. But is that a process that you would be willing to do? Mr. Brennan?
Of course, no objection.
All right, so we'll try and figure out something that.
It's about
that-
like professional occupations, not just cops.
All right, the list of witnesses, you both have a list of witnesses. I told you you needed to combine them so that I can.
True that.
Need a UGC
Oh,
video
for
for your
fuck's
business?
sake.
Find me and many other skilled creators on Fiverr. Or you could.
We have not combined them.
All right, so I need you to look at that, and a statement of the case to read to the jurors. It's all part of the final trial conference. So I should have had it last week. So
Yeah,
I'll
it
need
should have
that
happened last
by
week.
Thursday. Is there anything else we need to discuss today?
There's still a few outstanding issues. One is ARPA.
Yep.
And
Where do
so,
you stand with discovery on that?
I received some TUI letters last night. It is not the information I was seeking from my motion that was allowed by the court.
Ooh.
And so I have grave concerns about waiting till the day before their testimony.
Yep.
To the other discovery that I think I'm entitled to.
What do you
Yep.
say, Mr. Jackson? James Jackson.
Your Honor, I do not know what Mr. Brennan is referring to with regard to what he's looking for and great.
They've told you
concerns.
15
I
times.
It is unnecessary.
So there was a motion allowed, so that should be able to, there was a motion for the discovery allowed a while back.
It
So
was.
that should narrow,
Right.
right?
Pardon me?
That should narrow things.
It does, and we have not, I attempted to confer this
No, you didn't.
morning with Mr. Brennan. And my recommendation to the court would be for us to confer further, because I just don't
No.
understand what he thinks is out there, but we haven't conferred fully either.
Okay, all right, so do that, we can address this next week.
No.
I think we're going to have plenty of time to sort of tie up loose ends during the impanelment process, because I think it's going to take a very long time.
Compel it, Your Honor. They're not going to give it.
Understood. And I expect we'll file a response to a proposed expert who received a report last night. And I didn't receive it until later, which I want to have a chance to respond to.
Exactly, Suzanne.
And Your Honor, if I could, please, one more item when it's appropriate for Your Honor.
That's okay, go ahead.
Thank you. We did receive the, Your Honor may recall the argument over Dr. Welcher in Your Honor's direction, request, and then the assent of the Commonwealth that they would redo what they had provided, that 140 slide presentation. We did receive that, but we received a lot of other material in addition to that, huge megabytes. I haven't even been able to open it up. It takes so long to open it up.
Oh,
I
wow.
respectfully request that we, Your Honor, grant us please 2 more days than what we had to take a look at that, because it's just taken an extraordinary amount of time.
Okay, makes sense, Mr. Brennan?
I can be clear, there's no new information. What Mr. Welch did is that all the information he based each of his opinions on was in the gigabytes we provided to the defense, but he wanted to make it as seamless as possible, so to effectively hold their hand through it. He put each site under each slide so they can find it in the file folders exactly where it is. So it's instructive and helpful, but it's not new.
Your Honor, if I may, I don't disagree with Mr. Brennan's characterization.
Oh, but I still need 2 more
However,
days
it
because I don't
is
believe him,
still
right?
140 slides or so. I was expecting a rather substantial narrowing. So
Exactly,
what we
Bree.
have to do is we have to go And unfortunately, I think Your Honor is going to hear similar points that we made, but it's going to take more time because I had the expectation, maybe unreasonably so, that it would be a narrowed slide presentation. So I'd appreciate the 2 extra days.
Yeah, please sit the fuck
So
down.
when does that put us at? What was the time frame mentioned?
Yeah,
I'm
exactly.
Sorry, Your Honor, I don't have the specific date.
There's
Can't
so
do it
many
now.
of you.
The time frame.
Spread out the work.
Yes.
Well, we were supposed to exchange discovery yesterday. And so I had that presentation sent over last night. They sent over the 2 letters. And I received the third dog experts report.
If I could, Your Honor, I maybe Attorney Brennan misunderstood the question. He is correct that he provided us with the presentation.
Wow, well,
last
how
night.
presumptuous.
But the question, I believe, Your Honor, was when was our time? Because Your Honor had given us time to respond. And I apologize, I don't have that date, but what I'm just.
They don't ever have anything done. There's so many of them.
I don't think I gave it to you.
Yeah. Okay.
So you have 2 days to respond to that.
I have 2 days from today.
Yes.
Okay.
Yes.
So there are a few matters outstanding. I will have the decision on the motion to dismiss, should by the end of the day, buffer zone, probably by the end of the day. And I'll get everything else done as quickly as possible. All right, anything else?
The only
Nah.
thing is the logistical issue as it pertains to both the voir dire process as well as during the trial. I wanted to ask the court if there was a mechanism by which Ms. Reed could have at counsel table some sort of an earpiece or headphones or something that's slaved to a microphone up at the bench at sidebar so that she can listen in on both.
No.
It's very.
She can get the fuck
I
up.
want to avoid that if possible. It's clunky. Especially during the voir dire process. I think it would be uncomfortable, and quite frankly, I think it would be a little inappropriate to have jurors with Ms. Reed standing right there with them and with us.
That's how it's done with every other defendant.
It makes sense all the time, but
Maybe something you're choosing not to, but she has every right to be there at sidebar. So you say you don't want that, you want accommodation. I don't know if we can do it. I'll think about it.
we could.
No. She doesn't get special.
We're talking about is potentially a closed circuit wireless microphone up the bench and a set of headphones here that she can listen in.
Put it all in writing. I would like to have had it before.
That's
today.
so ridiculous.
It may not
Yes,
be-
Harpo. Exactly.
So the alternative is she can come to sidebar.
Yeah, she's fucking special, all right.
Gentlemen, whatever, it's her absolute right. If she chooses not to do so, I'm going to need you to tell me that.
I'll put something in writing and perhaps I've got the plan in the back of my head. I'll put it in writing.
I wanted to ask if there's an objection from the Commonwealth for that.
It's priority, it's in the courthouse, so I'm not very hopeful that we can accomplish this in the next few days.
Okay, well, thank you for entertaining.
All right, one thing, when we get the juror questionnaires, the supplemental juror questionnaires that we talked about, and I need you both know what my decision is here, other than the 10-2 versus automatic. Let's go
Yeah,
with
she
10-2.
does. Freak.
And I can either do that inside or in the form. What I'd like you to consider, and lawyers have done this in other cases that I've had, is if there are answers that are clearly what you believe would both sides agree jurors excused for cause. In an effort to be able to go through this vast amount of jurors that the jury commissioner's office was kind enough to summons in for us, if things stand out to you, it would be ideal if you could agree that jurors number 8, 12, and 16, both sides agree should be excused for cause based on the supplemental questionnaires. It would be very helpful if we could do that, and maybe keep a running sheet that would be a joint proposal to excuse these jurors for cause. It may happen when you look through the questionnaires on folks that we sent home to have them come back the next day, to just call 5 people, the court officers call them and tell them not to come in based on the questionnaire. So please think about that. It makes sense to me. It was very helpful when lawyers were able to get along well enough to do that in case that we try.
Yeah, well, that's not going to happen here. It's not reasonable, Bev. Come on, dude.
Because of the pre-trial publicity also. All right, anything else?
They're not going to get along well enough to do any of that. Like, it's common
There
sense.
was a motion for reconsideration that was filed with regard to the metadata underlying. I can.
You can make an objection. Go ahead.
I just wanted to make sure that the court saw that motion and that it was filed. I don't know if the court wants to hear a full argument, I'm happy to do that, but we just wanted to make sure that that gets decided.
Okay. All right, there's still a few outstanding.
Thank you.
All right, anything else?
We really should.
We'll see you on Tuesday.
I agree, Eva. I mean, Penny. I agree. The problem with that is DNA wouldn't have the space to host us. It's very small. There's only one table. So that's the only thing is they wouldn't have the space to have us all there. She always grins. That's what she does, you know? Like, I mean, that's essentially like what's happening. Like, I'm sorry, but I really think that the judge should be taking control of our courtroom to sit there and say, like, I really wish that they would get along enough to do X, Y, or Z with the jurors. Like, that's not going to happen in this case. If you didn't already realize that, I really don't know what would make you understand. They are not going to get along because the defense can't stop lying. Okay? Just can't. Like, they cannot stop lying. It's just, unfortunately, what's happening. Like, so she's saying she'll have the motion to dismiss, the answer for the motion to dismiss, which we all know is denied, by the end of today, and the answer on the buffer zone by the end of today. So I don't know. Like, it's ridiculous. Like, I'm not sure, Anna. I'm not sure if we are back. I'm not really sure if they're just doing lunch or they're, I don't know. I'm not understanding. I mean, she didn't schedule anything else, so I guess and it's still on and it hasn't, wait a second. The camera's moving, so I'm not sure if they're about to shut it off, shut it down. I'm not really sure right now. Right? Let them party in the lobby. It's just, I think we all are, Jack. Oh God, I think see, there it goes. It went off. Like, I think that was it for the day. Like, I could be wrong, but I feel like that was it. They do have one more pretrial conference, that they have to do because they were supposed to do pretrial conference already last week and stuff got pushed back. So they're not doing it until, I don't think, probably at least next week. But again, that's got to be before jury impanelment on the 1st. Karen's team also went to the First Circuit. And after the federal judge said, no, we're not going to stay your trial, then they went to the First Circuit to have the trial stayed. And that's not going to happen either. So, like, we're still waiting for the First Circuit to come down and say no. So, I know, Jack, it drives me nuts. Like she doesn't understand the peripheral of all of it. Like, and she does. That's what gets me every time, is she absolutely 100% does understand. So it's like, why are we doing this song and dance as if she doesn't know that they're not going to get along? Hank had a solid legal footing on asking for those specific communications. Karen absolutely waived her right to those, like, unequivocally. So, and that's another thing. What about ARCA? They still haven't gotten all of their reciprocal discovery on ARCA, and the defense is sort of over here moaning like, we don't know what else Mr. Brennan thinks we have. Like, well, we know, and even the judge knows that you have more than what you're giving. We still don't know who said what in their report. And we've said this a billion times, so there's no excuse now. Like, you need to give the reciprocal discovery from ARCA to Hank. Because if that third person that wrote that report wrote certain parts of it and there's a reason why they didn't use that third person, Hank may call that third person in and say, okay, what was the reason that you were not ultimately used? Is it because you said that if you were given more evidence that your, opinion could change? Like, and I think that they've been holding off on trying to give it to them because they know that's what's going to happen. They're not idiots. They know exactly what's going to happen, and that Hank will call that third expert if he has to from ARCA that they didn't call. Like, so they're just delay until, I don't know, they think the Commonwealth's going to forget. I assure you, Hank pays he's attention to detail. He is the attention to detail. Like, his middle name should be Detail. Okay. So this is not something he's going to forget. Like, I agree with you on that, Jack. There's no reason he should be in there. Sorry. You have 20, felony charges, most of them for witness intimidation and picketing witnesses. And there's no reason he should be there. None. Especially with ongoing harassment. But as long as he's on that witness list, he cannot be there for trial. So I think the pretrial conference would be the last thing he would be allowed to be at. It's like, why? I think at that point, though, what would happen? Somebody would have to ask him to be removed. I mean, the judge could do it on her own. They could argue bias, but the Commonwealth could ask that he be removed from the courtroom because it's inappropriate and it affected the last trial. Like, it's not rocket science. Oh my God, lawyer, little. Oh my God. I can't imagine. And it makes my head want to explode because the misinformation that they push out there just to have donations from the mob come in is amazing to me. I know what those donations from the mobs are like. Okay. They come fast and there's a lot of them. And at the time, you're just like, oh, people are appreciating like my coverage. And like, because I didn't know that she wasn't way back. We had no evidence. We had nobody else talking about it. We had court documents, but the prosecution documents weren't really dispelling anything. So obviously, once I got evidence and was like, yeah, there's no way she's innocent, I knew that if I was going to tell the truth, I was giving all of that up. I was giving up the hundreds of dollars, in donations. I was giving up all of that. So like, they don't want to give that up. And it's like, okay, then you have no integrity. Like it's that simple. You have no integrity. Like, because ultimately, they're just saying it because they want these people to keep sending them super chats and donations. And I find it so funny that they talk about freedom of speech because they attacked my channel while it was monetized. And my monetization was paused for 6 months. I just had to reapply for it. Like, and there's no guarantee that YouTube will be like, yeah, sure. Like, but they attacked my channel so that I couldn't be monetized. So the only, donations I can receive are through Cash App, Venmo, and PayPal on my channel. And the only way my channel survives is if I can pay my costs and then maybe make a couple extra dollars after that. Sometimes I don't even make $10 an hour when I stream. That's not even minimum wage in my state. Like, so it's like they're all too proud to just keep spreading lies as long as the money keeps rolling in for them. And they know that the money's not over here with the truth. The money's in the conspiracy. Everybody wants this conspiracy to be a conspiracy. Unfortunately, there's no evidence for that conspiracy. Okay. As a matter of fact, there's 20,000 pieces of evidence against said conspiracy. Colin was not even there when Karen and John pulled up. Brian Albert and Brian Higgins have nothing to do with John's death. He never even entered that house. So it's just deplorable for them to sit there and say they want to use 3 people as third-party culprit that they know John never even entered the house. The judge should not allow it. She should not allow it. Like, that's another thing. Do you know, like, Karen still drinks a lot? Like, every event she's at, she's got a martini. She is drinking and drinking and drinking. Like, she didn't learn a goddamn thing. She didn't learn a goddamn thing. Like, Hank is brilliant. He absolutely is brilliant. I want to pick that man's brain when this trial is over. I would love to just sit with him and pick his brain. Like, oh, next Tuesday. See you next Tuesday, defense. I had to. You guys set it up for that. I have to. I know, right? I don't think that will happen, but still, he will be kept out as long as he's on that witness list. That's for sure. He's not allowed in the trial. So once jury impanelment starts April 1st, he would not be allowed there. Yeah, more like piece of shit is right. Well, that's the thing, is they just stay lying. And it's like, I understand the beginning, what it's like to give it up, but they like, I was a small channel that just started. And when I realized she was guilty, like I knew my choices, right? And I knew which choices I could make and which ones were going to hurt me and which ones were going to help me. I knew it was going to hurt me when I realized that she wasn't innocent to come out and say that. I realized I was going to lose thousands of subscribers, and I did. Okay. I realized all of that. Some of these people had way bigger channels before all of this, right? So they were already like getting a good flow of like covering their costs and making money. Like they already were doing that. So they don't really need this on top of it. That's just pure unequivocal greed. That of course they don't need, they want, right? Most of these people like Emily D. Baker actually quit being a lawyer because she was making more on YouTube. Said something like it was like between like 150 and 250 grand on YouTube. She makes more than she ever made as a lawyer. So she quit being a lawyer. Like, also, she worked in the same office as Jackson. So I can't believe a fucking word that comes out of her mouth. But a lot of them just repeat and parrot what another one of them said over and over and over. And the ones that are lawyers, I say shame on them because they know that they're lying to their audience. They know what they're spewing is nonsense, yet they keep doing it. That's what gets me. That is what gets me. Like, no, I have never heard of it. That's another thing of a defendant having their own microphone so they don't have to get up and go to sidebar. I'm sorry, what? No, if I was the Commonwealth, I absolutely would be objecting to that because it's because she doesn't want to be right next to the jury. Well, that's too bad. You're the ones who wanted the smaller courtroom. It wouldn't have been like that if you didn't bitch and whine about the courtroom in the first trial. So you get the smaller courtroom and you got to get up for sidebar. That's how it works. Every other defendant on planet Earth has to get up. None of them get headphones to listen in to sidebar. That is absurd. If she wants to listen in at sidebar, she can get her ass up and walk over like everyone else on planet Earth has to do. Like, it's the judge's job to make sure that the trial stays on track. So I have no doubt that jury impanelment will start on the 1st. But the problem being is I really hope that the federal court can hurry up with their denial of this BS because she's not going to swear that jury in. Bev's not going to swear that jury in until they get an answer from the federal court. And that could push things off, like even after they impanel the jury. So like, it's like the federal court needs to hurry up and get on their shit because we have a trial that needs to start here. Like, yeah, well, we should do that then. Ashley, we should do that because it's harassment. It's to hurt the people they've already harassed who are willing to tell the truth because there's not many of us and there's a reason why. The reason why is the ongoing harassment I receive every single day of my life, dude. Every day since the winter of 2023. Every freaking day. Like, there's a reason why there's not people hopping on and just sharing what the truth is and not being afraid of it because they are afraid it's going to happen to them. And I cannot blame them because it is hell. Like, but I'm still going to do what's right regardless. It does suck. Like, it does suck sometimes. Like, it is what it is. But there are so many people who have been victimized by this in this case and Karen and fucking the sewer turtle. Like Lindsay, and I like to think that like people remember her and keep her right here, but like that's not true. People forget that she exists or they believe the bullshit he has spread about her, which is unholy, unequivocally not true. And she needs our help and she needs our support for her legal defense fund. And the only way she can fight this ridiculous civil suit to keep her quiet is with our help, And so it's like, I feel like sometimes I'm the only one trying to make sure everyone gets the help that they need. And it's frustrating. It really, really is. Yeah, it's common sense, right, Kelly? That like, there's no way they're going to get along. So for the judge to even say it, like, we know that they've lied repeatedly. You said that in court, like, and on purpose. What would make you think that they're magically all of a sudden going to stop doing that and get along? Like, come on, dude. What's funny about his laptop is his laptop just sits there and 9 out of 10 times he never writes a single note about what's happening in court. And I'll tell you why. It's because he's not actually listening. He doesn't listen to anything that's being said. Nothing. What he does is when he gets bored of hearing blah, 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 because it's all he hears in his head. When he gets bored, he goes online into chats and into like different people's streams and types into the chat or watches it for a minute. Like, why are you watching a stream, watching the room that you're in? Does that make any sense? Like, bye, Anna. Love you bunches. It's quite a few channels that they like to attack, you know? Oh, the lawyer, has to know he fucked up, but it's like, he can't go back now, you know? Oh, Larry's just an ambulance chaser in my book. Like, he's just one of the shittiest people, the DUI guy. Yeah, he's just a shitty, you know? And yeah, he started going after people. Yeah, he's as bad as the rest of them. Like, that Emily had her on his laptop. How could you guys see his laptop from this angle? I'm confused. I think I just did. I think I just did. We just went over some of the jury questionnaire. They didn't tell us the questions. Obviously, they went by numbers, saying some of them needed to be changed, some of them needed to be tossed. They heard the arguments about why she should give Yannetti's communication with Karen to Brennan, and she denied that. I mean, there wasn't a ton that really happened, unless he made a argument he didn't even need to make, and half of it made no sense. She will ruin them all. You are absolutely 100% right about that. Also, so with the sewer turtle, because they made the mistake of continuously lying, and some people know that they're lying for 1,000% fact and are just not saying anything, and there are actual pieces of evidence to prove that. So I find it funny. They're both going to be the downfall of this whole thing, and everyone else who followed them into the hellscape of doing these awful things to other people. It's called karma, and she is a bitch, and I promise you she will come. Absolutely. Yeah, I'm surprised actually that he didn't bring that up, but at the same time, you'd have to have a motion to bring that up. You wouldn't just bring it up randomly. So maybe he addressed it with the court. I don't know. I'm also hearing some other things privately that I can't exactly tell you guys right now, but just know that I am working on it. And if there's anything that I can give you guys right away, as soon as I can, you guys will be the first people to know. Yeah, see, that's just weird. That should never happen, Ashley. Never. No, Hank can ask for a motion to reconsider, which is a motion to reconsider you saying no, basically. It's a motion to reconsider the judge denying your motion. So he can do that, but really all that does is say, Your Honor, I want you to reconsider because of X, Y, and Z. Most of the time they still say no anyway. The defense is still waiting on that motion to reconsider, one of their experts, and it's going to be denied again anyway. So it is a mountain. You are right about that, Harpo. I feel like sometimes it's really hard to climb it when you feel like you're climbing it alone. And it's not that I'm the only one talking about this. As we know, that's not true. But I feel like everyone's sort of climbing to the top of the truth mountain on their own instead of coming together to push each other up the truth mountain. And that, I see a huge problem with that. And maybe that's the advocate inside me. Maybe that's the, work that I've been doing for 18 years, helping other people. And I do it when I can't even frigging help myself. But I just feel like people should be working together, and that's always how it should be. And I realize that that's not feasible and it's not realistic. But I just wish that it could be that, I think the court needs to ultimately do something about it. You have to call the court if you think you have to call the court directly, the Dedham Superior Court. But that's what pisses me off too, Kelly, is why hasn't his channel been shut down completely? I mean, he's been demonetized forever, so he's not allowed to ever monetize on YouTube. But other than that, they have never shut him down, which they should have done a long time ago. He breaks the terms of service by harassing other people and the way that he does it. So he had that Emily on his laptop last week. Of course he did. It's just ridiculous. anybody he's like also jealous of too, like he'll flip out on. So if anybody starts talking about one specific person too much, whether it be LTO, the Young Jerks, or whoever, like if they start talking about that person too much around him and telling him how awesome they think that channel is, he will eventually snap on that person because he becomes jealous. It's MO. He's been doing it for years. Ugh, I can't. I mean, what you'd have to do really is talk to the SJC that issues the press passes and ask why he's still allowed to have a press pass with all the behavior that he's exhibited. You know? Oh, they do forget that, but they'll just move on to something else after, you know, and all these people, all these cultists will believe all of this and believe that they're awesome and they know everything, and they'll follow them to the next one. And they know that, you know? So that's very true. I would rather than be a liar, but I can't say that it's easy. That's for sure. You know, like when I get donations, mine usually go right away. Like it's usually for groceries or, you know, getting to the hospital back and forth. It's, you know, for Ubers to get to the groceries. Like it's usually goes right away to like actual real life, you know? For them, it's just like the normal everyday, like, oh, let me go spend $300 at the bar. Like, go spend $300 on your kids. Like, spend $300 at the bar. Like, it's insane. Like, yeah, he is disgusting. I know I'm not, Arbo, but it feels like that sometimes, you know? It just feels like that. Well, that's what we're waiting on, that answer from the judge, Michael, for the buffer zone. She said we would have that one and her answer to the defense's motion to dismiss by the end of today. So that's good. I'm going to keep an eye out for that. I keep an eye out on Twitter. Yeah, I mean, like I've said this before, every creator should make money. It's time and energy, and like, I'm not saying that creators shouldn't make money. I'm just saying it's when you step over that line into lying to your audience purposely and doing it just for money that it becomes a problem. Like, if you want to have any integrity and you want to make money, you should have to be someone who's not going to sit there and lie to your entire audience to do so. You're not just going to say the most popular thing to bring the most people to do so if you know that that thing is a lie. That's my point, you know? Like, Ari hates when people say that. Hates when people say that Ashley is his kryptonite. He hates it. It's something he does not like. He also doesn't like when you tell him he has little arms, right? Because he's really self-conscious about his arms. So just don't tell him he has little arms and that he's a little person. He really doesn't like that. Really, just not. It upsets him, okay? He gets very upset. He also gets upset if he thinks attention is being drawn to other people and not him, and he is not getting the credit that he thinks he deserves. Oh, yeah, he loves going into other people's chats, running his mouth. He was doing it earlier. I was showing like he was doing it earlier and then deleting it, which is so amazing to me. It's like, bro, you're in the courtroom. You're in the courtroom. Yeah, right? Baby dinosaur arms. Little baby dinosaur arms. Oh, I have a $5 donation from Eva. Thank you, Eva. I appreciate you. Thank you so much. She said, feel better. Thanks for your coverage. I will try to feel better. My throat is still on fire and I have no soup at my house. I really need to get to the grocery store and get some soup. And I got a little bottle like this of raspberry lime soda that felt so good. It was so cold on my throat, but there's none left. Oh, yeah, the email. Sorry, I forgot about that one. Hold on. Go back. Ashley did write an email to the judge. Let me get it up on the screen. Hold on. Let me see. Why is it? Hold on. Boop. Let me try this. There we go. Share screen. Boop. Okay. So let me make it bigger. I don't know. because I don't have two screens. I only have one, so I never know if it's like I got to go back and forth to see if it gets bigger or not. All right, hold on. Let me make it even bigger. Can I move it over? Oh, yeah. Here we go. So it says Aiden is in court making faces, in my opinion, in an attempt to provoke reactions of the viewers. Aiden is as well going into chat groups. He knows he is not representing his opinion and sending messages to that group, then deleting the comments he makes. I took a screenshot of one of the comments to provide to you. He's antagonizing the group in court instead of listening to the evidence being provided. He's using your court to harass people directly or indirect. And he has orders not to do that, you know? I know, right? That's what she said. That's what he wishes he could say. Oh, that poor small man. That poor, very small man. Like, but I think it's important, you know? So I'm hoping that they push that buffer zone much further away, and a lot of the businesses actually ask the same thing because they have a farmers market that happens in the summer, and they asked the same thing, like it needs to be pushed away from their businesses and that farmers market because it affected their businesses. And that last summer, it's during a summer, dude, that's their peak time usually. So like you're hurting. People don't want to go into that. They're not going to want to go into a business that's behind a pink mob, you know? So I'm sure those businesses lost quite a bit of money just from that last summer, and they were not expecting it to happen again. Like, and here we are doing it again, you know? Like, ridiculous. She'll buy pizza for the first luncheon in the jury box. Can she buy me pizza? I would love a pizza right now. Just a good pepperoni and onion pizza. Oh my God, that sounds so delicious. I'm not even going to lie. That sounds so good. Sounds delicious. Like a cold ice cream sundae. That sounds really good too. I ate the only ice cream I had left because it felt really good in my throat. So last night I ate what was left of the, I'm not going to lie, mint Oreo is my favorite, but I'll also go with mint chocolate chip or Oreo. I do have tea, but sadly, I drank the last tea bag 2 days ago. Do hot coffee, though, in the morning. She doesn't deny everything the Commonwealth wants. We'll give her a little credit. She does give some things that I think are kind of no-brainers, but I do think she heavily leans towards giving the defense things that she probably shouldn't, and that I don't think most other judges would have. I don't think they would have allowed Arca back in, not by a long shot, any other judge. I don't think any other judge would let Marie Russell testify because that lady, if she's an expert, then I'm a friggin' expert in tap dancing. Like, you know what I'm saying? Like, it's just not, these are very clear things that I don't think another judge would have given them, not by a long shot. So, you know, that's exactly it, Kelly. Is they're afraid because they've seen what's happened to other people, including myself, including Lindsay. Like, I mean, Lindsay said nothing for 6 months. She said nothing. These people bashed her, defamed her, slandered her, lied about her, and she said nothing for 6 months. And then when she finally made her own Twitter account and started defending herself, what happened then? They tried to use her defending herself as a reason to why there shouldn't be a restraining order because she was defending herself. Well, they twisted that and said, oh, well, she's saying stuff online about it, so she must not be afraid. No, she's getting phone calls and text messages and emails, and her children's schools are getting the same thing every single waking day from your mob of people, okay, and being harassed into oblivion, all right? So she decided to start sticking up for herself. And then she did. And then they tried to use that against her too. It's like, when is it okay for a victim to stick up for themselves? When? They're just never allowed to, or that gets used against them? That's disgusting. It's utterly disgusting. What she has been through is utterly disgusting. What her children, what her small children have been through is disgusting. She's a single mother of 4. 4 babies, 4 children. Okay. And everything they've been put through is, I'm sorry, but I don't care if I have to do it until I'm old and gray, but I will make sure that I fight with every lawmaker from here to Kalamazoo in this state to make a law so this never happens to anyone ever again. This is never allowed to happen to anyone. That victims and witnesses are treated with much more respect. That the law enforcement and lawyers don't get to choose whether they're going to do their job or not. They don't get to decide that they're afraid that they're going to be smeared and lied about. So they just won't take on a case, or they won't charge someone with a crime. That can't be allowed to happen. That's not how our justice system works. You can't just say like, oh, we're going to allow him to commit 52 crimes because he's already charged with 20. So like, well, unless he like murders someone, then we'll charge him. But like, if he doesn't do that, like, we're just not going to charge him with anymore because it's already too much work. Like, no, your job is justice and applying the law equally, not deciding that because he might put your address out there as the prosecutor, or he might harass you or have his mob harass you as one of the cops that arrested him, that you just don't have to do your job. That's disgusting. That is disgusting. Unfortunately, Dewdrops, you can't do that because the court actually isn't supposed to be saving seats for anybody, not the defense, not the prosecution, like not the witnesses, not anyone. They're not supposed to be saving seats for anyone. It's a public trial. So I think this part, like, this is where it'll get tricky in the next trial, is it's first come, first serve. If the public wants to sit in on that trial, they have every right to sit in on that trial. So if I get there before 17 other, people who sit on the Reed side, then I have every right to sit in that courtroom and watch that trial. I'm the public. It's a public trial. You can't close a public trial to just family and friends of both sides. That's the problem. And I saw a problem with that last time, and at least they're sort of recognizing that problem this time. You can't really save seats. It's first come, first serve, and that's it. I'm hoping she will deny third party as well, because they have to have evidence, and you can't have evidence of something that doesn't exist, right? Like, so that's not exactly what happened. I did watch it yesterday, Bradel's hearing from the BBO. It's not exactly what happened. So what happened was, the lady Pam that's on the BBO council, she can be a little much, and there was another woman who resigned because she felt like that woman Pam was sort of bullying her and being very aggressive. And Pam made a comment in sort of that I guess you could say would be bias for not Bradel, but this sort of co-defendant, if you will, of the BBO. I mean, it's not called co-defendant, but co-counsel or whatever they call it, co-respondent. The other prosecutor that worked in the office with Bradel when all this happened, who has a little bit less culpability in all of it, but in support of like her sort of, and then resigned in the middle of all of this. So they had already done 6 days of evidence and all this that they don't show the public, which I think is shady as fuck. But I think the BBO only shows the public the 30-minute argument parts for both sides. I think that's deplorable. That's also something that I'm going to make sure, like, when all of this is over, that I work with my lawmakers to change, because the BBO process already is a good old boys club. It really is. Like, it just bottom line is they don't do shit about some of the lawyers or judges that should be disciplined. They get a slap on the wrist or they get nothing at all. And it's deplorable. It shouldn't just be run by lawyers. We should have normal citizens in there, whether it's paralegals or people who, teach law or whatever, like whatever it is. We need to have regular citizens in there, not just lawyers, because clearly, just like the police shouldn't be able to police the police, you can't have lawyers policing lawyers, because nothing will ever get fucking done, right? So, we have all of this nonsense happening at the same time. So I think at first it kind of looked like, oh, here we go again with, Bradel and Chibi and his minions harassing people into oblivion. Although now that they put her name publicly out there on that BBO hearing, I'm not too sure that that's exactly what might not happen at this point. But, fingers crossed they leave that poor woman alone. I'm not going to say the attorney's name that resigned because I don't want her being harassed. But yeah, no, this can't happen again. And I will, Scorpio Moon Gal. I really will. I will put on my Twitter or tell you guys here, like when and where I want to help you guys, have you guys help me write letters and call lawmakers, because it doesn't just need to happen in my state. It needs to happen in all of your states. So it can't happen there, right? So if you don't live in Massachusetts like I do, like, it needs to happen in your states too. Like, you gotta call your senators too. Like, this is something that should never be allowed. Like, a prosecutor shouldn't have to worry about being doxxed, especially by someone who's been charged in that specific case of intimidating witnesses. That's deplorable. He should be behind bars right now just for doing that alone. Like, it's absurd. Like, yeah, and because I'm sick, I can't go up to the hospital where my child is at the moment because she has no immune system, and I can't get her sick. It's not just a cold to her. And especially since we're trying to figure this whole bone marrow transplant thing out for her. So until I'm not sick anymore, I can't go up there. So that's the shit part with that. I know. I agree with you there, Dewdrops. I completely agree with you. I think it is gross. And then they tried to keep out the witnesses for closings. You cannot keep the witnesses out for closings. They have every right to be there, just like any other member of the public. It's just, I know, I know, Harpo. And this is what I mean. I don't care if it takes till my dying day, but here's the thing. We have cyber stalking laws on the books. Try to get your cops to actually enforce that law, though. Try to get the FBI to actually enforce it. See how that works out. What's the point of having laws on the books if our law enforcement isn't going to enforce them, or if they're going to choose to use their discretion not to enforce them? That's the problem. So, I mean, the problem needs to be that no longer are the police going to be allowed, just like when it comes to domestic violence, where they can pick up the charge, and they have to arrest someone. Like, that needs to be something that happens when it comes to this stuff too. It can't just be they decide they don't want to, right? Like, this has to be now a law that they can't choose to do their job or not, that they absolutely have to do their job. You don't get to choose anymore. You don't get the discretion anymore because you wasted that discretion on being afraid like a big baby. Sorry, but if you took a job in law enforcement and the justice system, you knew exactly what you were getting yourself into, whether it came to mobs, whether it came to triads, dangerous people. You don't get to say, no, I don't want to. That's not the way it works. And since they are allowed to do that, apparently, whenever they want to, something needs to be done about it. And I will make sure that I am a part of making sure that this can never, ever happen to anyone ever again. She did deny it last time, but she still allowed them to develop it, and they sort of ran with it. So even though she denied third-party culprit last time, they still used it. And that was Hank's point, was it unfairly prejudiced the Commonwealth by them just being allowed to anyway. Like, no, she didn't give a shit that they had no evidence the first time. You are 100% correct. She also didn't give a shit the first words out of Yanetti's mouth were like, oh, well, she was framed. That he should have been stopped right there and struck from the record. Like, and she just let him continue. Like, it's crazy talk. It's absolute crazy talk. Like, well, she better not be. They better leave that woman the hell alone. Like, I do think she gets a little worse as we go. I can't, you're right, find any legal basis other than her being afraid of appeals that would be denied anyway. I got nada. Just like you. I got zilch, nada, nil, nunce. New York. Hey, that's a big place. That's actually a good, like, place that, like, laws come into place a lot of the times in the New England states. If one of the New England states does it, a lot of the other ones tend to adopt it or a part of it, you know? So I know that she appreciates the support when it comes, but oftentimes you feel like you're alone, right? Because I think people just seem to forget that she, like, exists and is still going through this, and she very much still is a person still going through this. And um I tell her that I support her, but that sometimes doesn't feel like enough, you know? Like, people should let her know in any way that they can. If you don't have a way to get in touch with her, you can always tell me, or you can say it here. And I know that she watches, so, you know, she'll see it. Like, but that she has support. She isn't alone, because it can feel like that. Absolutely. And they do. They twist everything, anything they can in a pretzel. Take the context out of whatever you said above it, below it, and they completely take it out of the context it's in, remove it, take the narrative they want and say, this is what this is. This is a conspiracy. This is all this giant, like, oh, there's a conspiracy with Lindsay, Kate, and Leah. It doesn't exist. It never happened. There's no conspiracy with Lindsay, Kate, and Leah. There was no conspiracy, period. But certainly not one involving them. I know, because I've seen everything. So I don't know where, like, in what cuckoo bananas world they live in, that they're going to still keep claiming there's some giant conspiracy that does not exist. So not only does Karen Reed have a conspiracy, but Aiden has a conspiracy because he's also been set up, right? What these people don't realize, what the cultists don't realize, is long before this case ever existed, Aiden was claiming to be set up, and everything that he ever did wrong and got caught in. Every time he said he was set up. Come to find out, all of it was a lie every time. We're just repeating the same thing over and over. But because they don't know this, right? And because they don't listen to any of us, they just believe him. It's absurd. It's insane to me. Like, you would rather not take 10 seconds, 10 minutes of research to look into this shit yourself than to just listen to what he tells you, knowing he lies? Dude, the people that say, like, oh, he brings receipts and he doesn't lie, are the people that blow my mind the most. Like, bro, if you listen to him for an hour, you can catch him in at least 3 lies and contradicting himself in one sentence to another. Never mind if you go back long before this case ever existed and the things he did before that. Like, what? Well, that's also a problem, Ashley. Exactly. Because there's so many people that will try to just be your friend, to just be a scumbag. Like, you know, it's just insane. Like, I was talking about one of the sewer turtles victims. Ugh, the glare makes me just want to. Yeah. Middle school female students. Yeah, well, that's yeah, exactly. Someone just made him. They just set him up for that, or he was creepy, or that poor girl at the football game. Yeah. It's just gross. Like, this is the kind of stuff, this stuff right here. I can't even, like, read this because it makes me so sick. Like, the things that he does to try to be right are reprehensible. And what's worse is he knows what he's doing, and he knows that he's lying, and he will continue to lie until he's dead. He will never take responsibility for anything. Like, ever. Like, this is awful. Well, I think let's not get ahead of ourselves, because make no mistake when I say that the Commonwealth it's not the judge that gets to decide whether Karen Reed is guilty or not guilty. It's the jury. And remember that the last jury didn't buy the conspiracy. And I told you guys during that trial, the jury is not going to like a pick one anyone, right? No, the defendant doesn't have to prove her innocence. But if you're going to do a third-party culprit, you're going to want to give the jury an idea of who, why, when, where, and how. And if you can't do that, and you're playing well, it could be this person, well, it could be this person, well, it could be this person, well, it could be the dog, the jury isn't going to follow that, okay? They're not going to do a pick one anyone. They're going to want to know, well, if it's not you, who do you think it is and why? Because if you can't point them to anyone, then they're just going to go back to what the evidence is on you. That's not hard to figure out, you know? Like, and that's another thing. I don't know how you turn a 15-year-old having a relationship with a 49-year-old, and you as a parent trying to stop that when your child runs away and your ex-spouse is allowing it, right? Like, how you turn that into slut shaming. Because that's what the sewer turtle told this 15-year-old child, is that her parent was just slut shaming her, not caring about her, not saying the 49-year-old was a creep, clearly not the parent trying to protect the child, but no, she just slut shaming you. Like, that's absurd. Like, absurd. I don't know if it'll straighten them out, but they can keep them there as long as they want. Sayonara. Like, it is really sad, Scorpio, that they can't. It's like, use some critical thinking skills. I would appreciate that. Well, there are many reasons, SMK, that I am not a paralegal. One being I have a terminally ill child. 2, I am disabled myself. And 3, I do not have the time to do really anything besides breathe most times. I would love to go back to school and be an attorney. I would love to do that, but I know that's just not in the cards in my life. You know, my kids' health is more important. My own health. I have a lot of health issues now. Thank you, COVID. I appreciate that. Chronic pain issues. That's why I squirm a lot in my chair, because I'm in a lot of pain. But mom is always last on the list, right? I got to take care of everybody else first. I also have other children. So I can't afford $40K in childcare either. So someone's got to be home to put my kiddo on and off the bus, my little one. If I could afford the 40 grand in childcare, that'd be great. Me and my husband cannot afford that. I wish I could. I actually, unfortunately had to, when I was using all of my paycheck when I worked at the prison for childcare, like, it was literally your whole entire check. You were losing money by going there. It was insane. Like, but if there was an attorney that was nearby that I could work mother's hours at, which is really hard to find for paralegals because they do most of the work. They do most of writing up the motions and stuff. Like, a lot of the work is done on paralegals. People don't give them enough credit. The paralegals do the majority of the work for the lawyers. But, oh, thanks, Jimbo. I appreciate it. Yeah, exactly. Breathing most of the time is not on schedule, Yep. It's just absurd. Like, I mean, it is a disability these days. You know what I'm saying? Like, exactly. Some people don't even make 40K a year. Massachusetts is extremely, you guys forget, like, some states you guys live in, the rent is not as high as it is here. A 2-bedroom apartment is over $2,100, up to almost anywhere between $2,000 and $3,000 per month in Massachusetts for a 2-bedroom without any utilities included. That's what we're dealing with here. It's like California. So it's pretty bad. So, I mean, you got to do the math, right? Like, we struggle busing it over here. We are the working poor, unfortunately. Like, yeah, that's another thing. These poor people in SSI, like, what they only make $12,000 a year. It's like $1,000 a month. That's all they get. If you lived in a state, like in one of the like cheaper states, like, maybe that could work, maybe, barely. But living in a place like California, New York, Massachusetts, Hawaii, that's not even a half a month of rent. The whole thing, what they get paid, people on SSI. I feel just awful for them. Like, it's not normal. 600, like, that's not. And I know all of Ellen's, I know her. So I know all of her stuff, like her medical stuff, and it's a lot. So, like, no one can afford to live on that. No one. That's not okay. Like, it's insane to me. Like, it's not okay. It's not okay. So it's like, it's funny to me because like you'll see a lot of like class war with the cultists where they'll be like, well, I'm so rich and like everybody on the anti side is so poor. And it's like, I didn't know rich versus poor magically made you a good or bad person. Wow. Excuse the fuck out of me. Like, that's not how it works. I would rather be poor and truthful and poor and close to my family and my children than be rich and lonely or rich and very insecure, like some of them. Sorry, not sorry. You learn to love yourself, especially somebody like me that has PTSD. I have CPTSD, which is complex post-traumatic stress. You learn to love yourself, flaws and all, right? Flaws and all, because who you are is what you leave behind. People remember you not by what you looked like and not by what you sounded like, but for the things that you did, the impact you left on their life. So if you can leave that very small impact on someone's life, like they remember that. That's what they remember about you. That dash on your headstone when you pass away, the time that you're born, from the time that you die, that dash is your life. That little tiny dash on your headstone is your life. It represents your whole life. At least make that dash worth it, you know? If that means carrying my elderly neighbor's groceries, so be it. If that means helping him pay his bills online because he doesn't know how to, so be it. No, you don't get paid to be nice, you know? Like, I've been doing volunteer work for 18 years. I haven't gotten paid a dime to do it. But it's the right thing to do. If you have the knowledge that can help someone else and you can teach them how to then in turn help not only themselves, but someone else, like, then you do it. Like, then you do it because it's the right thing to do. Don't waste your life being selfish. Don't waste your life being self-centered. It doesn't bring happiness. Like, at least spend some of your life getting that amazing feeling that you get when you help someone else. Like, because you'll never get another feeling like a hug from someone who appreciates your help or just a thank you from them. Like, that feeling will never come from something else. You will never get that warm fuzzy feeling of helping someone else anywhere else. You just won't, right? And I wish people helped each other more, whether it's the stranger at the grocery store that you just saw, your neighbor, your sister, it doesn't matter, right? A stranger walking down the street. Like, do something nice for someone today, right? Just do something nice for somebody today. And it doesn't have to cost you money to do something nice for someone. Listen, once again, I'm a poor family. We are the working poor over here. So I don't have money to spend to help people, but I help people with what I know here. And it helps them. Like, it gets them the help that they need in other places. And so I do what I can. I do what I can to make sure that when someone calls me or emails me or texts me and they're sent by someone else or sent from another, I get people all the time that used to live in shelter that call me because I volunteer at shelters, like, and the workers there won't know how to help them. And they'll call me and say, is it okay if I give this person your number? Like, yes, of course it is. Like, and I will do whatever I can to help them get settled in the next phase of whatever they need. Everybody needs a little help once in a while. And it's not okay for people to, punch down on people that need help or kick people when they're down. That's shitty. If you're doing that, there's something wrong with you, not something wrong with the people that need a hand up. Like, it's sad, but like, that's what the sewer turtles thing is all about. Taking advantage of people who clearly can't think for themselves and taking advantage of the fact that people will believe anything that he says. And Karen Reed knew that when she basically hired him to do this PR job that dude wouldn't know how to do PR if you paid him. They should have just hired an actual PR firm. Because now, he got her tangled in this mess of communications with him, and you make no mistake, he's a narcissist. So even though she asked him to use the Signal app, I have no doubt in my mind that he screenshotted Signal conversations with her because he wanted to be able to brag and show people later on about it, or even during, like, oh, I know, that poor kid, dude, that poor kid. I don't even know how old the kid was at the time. 900 for my son. If I work, they take it. That's another thing. It's like sticking people in these positions where they're just stuck and no way out. And that's not okay either. You know, like, no, don't feel bad to say no to anybody that isn't a good fit as a roommate, Ellen, because you need them to actually pay their way and not to keep screwing you over because you're a kind soul. That's not fair to you. You have to. And I don't care what it is, but at least stand for something that will help someone or help many people, like, and we do have a great little community here. I love my community. My community is full of amazing and smart and kind people. Always good with the one-liners when I need a laugh. I always love that about you guys, even if I'm shitty day up here and in my brain, I'm just like, oh, I wish this day would be over. Like, I can come here and I know someone's going to make me smile and someone's going to make me laugh. And I appreciate that about all of you. Just know that when I come here, every single one of you is the reason why. So, before y'all make me cry, do we have any other questions? Do we have any other things you guys want to discuss quickly about what's going to happen next? We're just going to have pre-trial conference next. That's pretty much going to be the last pre-trial conference next week, and then jury impanelment. So that'll be interesting. But that's basically what's going to happen next. I will watch out, though, for those 2 motions. There'll be 2 that we'll get today from Bev that she said we would have by the end of the day, which is the buffer zone one and the defense's 4th or 5th motion to dismiss at this point. Like, yeah, my husband, he will shovel. He'll shovel my neighbors' like driveways and walkways especially when they're older, so that they don't have to try to do it themselves. Like, it's too dangerous for them to try to go out there. So he makes sure that it's clear for them and their cars. He'll clean their cars off. Yes, I can, ma'am. I can call you when I'm done. I have to pee first, but I will. When I'm done doing that, I will call you. Absolutely. Justice for John. And for all of the victims, the witnesses' families, Lindsay, all of you, anybody who has dealt with this kind of harassment, Ashley, I know a bunch of you have been victims of it. Like, to all of these people deserve justice. Every last one of them. And I know that it's coming. Like, I agree with you, Harpo. They are all, I know, right? To the pee-pee dance. That's what I should be doing, is like pee-pee dancing, but I don't have to pee that bad. I have to pee, but not that bad. All these motions to start fleecing the state. I think there should be like a limit. Like, listen, we're into the 4th or 5th one. Like, it's not being dismissed. Okay. It's not being dismissed. It's that simple. It's not being dismissed. There are no grounds to have this dismissed, period. No ifs, ands, or buts. Like, so I don't know why they're continuing on this ridiculous nonsense of asking for another motion to dismiss. Like, it's not going to be dismissed. There's nothing to be dismissed about it. Like, oh yeah, before I go, let me make sure I read everybody's. Oh, see, I almost forgot someone. I don't want to do that. Oh, thank you. Thank you, Jack. We got 1711 from Jack as a donation. I appreciate you, Jack. I guess since we don't have much else to go over at the moment, tomorrow is Wednesday, so you guys don't have me tomorrow, but you have me Thursday and Friday. I will pop on if there's a necessary need for me tomorrow. I have some things going on in the background that I'm trying to figure out what's going on. Nothing that I can publicly give you guys yet, but if there is a moment where I get the solid information that I can give, I will. You guys know he did say he would pee himself to keep warm. So solar weird. I don't know why he said that. Hi, Aurora. But as soon as I can give it to you guys, I will. I just got to work out a couple things before I can do anything with anything. You know, you got to make sure that like the information you're getting is right. You have to check your sources, and you got to check it with other people, and then you got to try to get documents. So I'm working on it. Okay. So anytime I can bring you guys something, it'll either come onto my Twitter or I will come here. A lot of the times if I'm home with the kiddos, it'll be Twitter, but I try to come here when I can. So okay, I made sure I got everybody. Did that. We did this. Okay. All right. Now I'm going to go to the bathroom because I have to pee. And I'm going to call Ashley because she needs me to call her. And then I'm going to relax before my kiddo gets off the bus. And then I'm going to make dinner. And then I'm going to do this whole thing over again. And hopefully maybe get myself some ice cream because my throat is killing me still. But I love you all. I love your stinking faces. As soon as I get the motion to dismiss answer and the answer for the buffer zone, I will put it on my Twitter and the Facebook page that I'm on, the Karen is Guilty Facebook page. I'll put it on that one too. So Dewdrop says, it's sickening the way she flaunts herself in the courtroom, and John's family have lost a family member. It's about justice for John O'Keefe. Yeah, it's really sad that she, like, it's just gross that she does that. It's really just gross. It's deplorable. But I do believe that karma will come, and it always comes to collect. And when it comes to collect, it's 10 times what you gave it. So whether it's good karma or bad karma, if you gave it, bad karma, you're getting bad karma back 10 times worse. So like, that's on you. I put good karma in the karma bank when I'm out in the community, when I'm out in the world. I put good karma in the karma bank so that good karma eventually, whether it comes back to me or my children or somebody I care about, then that good karma is out there, right? You don't want to put shitty karma in the world because that shitty karma will come back for you. Don't do it. Just don't do it. Put good karma in the world. Like literally, just if you got to hold the door for the person behind you or help the elderly woman in the grocery store, put her groceries in her trunk for her and put her carriage away. Like, just do something nice for someone. It doesn't cost you anything to just do something nice today. So everybody do something nice today. And I want to hear about it on Thursday. It's your homework assignment. It's your homework assignment. Do something nice today or tomorrow. Yep. Smile is an act of kindness. Do something nice. And I want to hear about it on Thursday. So you have 2 days, right? Like, do you understand the assignment? All right. I love all your stinking faces. Make sure that you hit the like button, the subscribe button. If you already haven't, make sure you change that little bell notification, because when you subscribe, it stays on some. So you want to change that little bell to all. Click on the bell and then the things will pop up and you go to all, so that when I'm live, you will get the actual ding on your phone that tells you that I'm live. I love your face. And thank you, Jack. And if you can, make sure you can donate to the channel. We really appreciate it. We are just a small channel and we only survive on donations from you guys. There's the information right here at the bottom of the screen. You can do so on Cash App, Venmo, or PayPal. If you do it when you're on my restream or my rewatch crew, my replay crew, which we love endlessly, then I will read it on the next one. We got a $10 run from Potluck the other day right after I hit the button to end the stream. So I appreciate that one, Potluck. But if you do it when I'm not live, I will just read it on the next one. So it's my way of thanking you guys and saying that I appreciate you guys, because I do. So I love your stinking faces, and I will leave you guys with the outro, and I will see you on Thursday. Keep an eye on X or Twitter, if you will. And I'll put those answers up to those 2 motions we're waiting for from the judge as soon as I get them. Okay. Love you guys. Bye.